Good morning. Hello, hello. I had to start a little early because I see that court is scheduled to begin at 8:30 this morning, and so that's like a minute ago. So I wanted to be sure that we get court from when it starts, and yet it was in time for the notifications to go out. The old gotta pay attention to the YouTubes. All right, so let me get over here. I'm just keeping an eye on it. Hey, Nikki Rex. Good morning. Good morning, Nonstop Mom. Good morning, Allie79. Thanks for being here, you guys. I know you have many choices on these YouTube streets, and the fact that you continue to choose me, I am forever grateful for. I really am. I'm not all the way awake yet. I have had my coffee. I have had my 5 hour. My intention was going to be outside and stream this, as it is a very nice early morning here in the Floridas on the Gulf Coast. And then I was getting all set up and I went outside, and the nature is acting like I live in a rainforest. There's all manner of birds and other wildlife making all kinds of noise. And then my neighbor has decided that it's Friday and he's going to get on his bullshit early today. On this Friday, normally his bullshit doesn't start till later on Friday, but yeah, he started early today. And so I was like, well, I guess I'll have to sit in the house and stream because it's too much background and it's distracting. Hey, and 5, 6, 7, 8. Good morning. Good morning. Good morning, Renee New. Good morning, Bowling with Cotton Balls. So this morning, we shall find out if Trevor Summers intends to testify. Now, here's the thing. Aw, Allie, I can't quit you either. Nikki Rex, I'm not all the way asleep yet. Perfect timing. Nikki, are you suggesting that I put you to sleep, Miss Ma'am? Just kidding. I listen to lots of people as I'm falling asleep as well when I go to bed. It's not because they put me to sleep. It's just because I like to listen. The question I have is, if he decides to testify, yes, Nonstop Mom. Now, I'd like for you guys not to try to attempt to get into my head because it's very messy and cluttered in there, and you will not understand the filing system. I'm curious. He's representing himself. How do you cross-examine yourself? How does that work? I'm very curious. And I just feel like I don't know how I've never seen it done before. So I have no idea how it goes because um I've never seen it. So I have no idea. But I also feel like this guy, the way that he has been, like, just who he is as a human and his behavior prior to the trial, then during the trial, feels to me like he would testify. And I just am like, I don't know. I don't know how it's going to work. Aw, thank you, Nikki. No, I knew what you meant, babe. I do it too. I just, right. Who will ask him the direct questions? How is he going to question himself? And what I guess would happen is it's going to be less like you can't ask yourself questions and then answer, right? I mean, I suppose you could, I mean, you can, every people are capable. I ask myself, what the hell did you just do that for all the time? And let me tell you, I also answer myself, I don't know. But I think that it's going to be more like just an for lack of a better word, a narrative, like he's just going to speak. And then I would imagine that depending on what his testimony is, right, then the state would object because I don't. Hey, LFT, good to see you, babe. Thanks for being here. Good morning. That's what I would imagine it would be like, because can you imagine if you're the court reporter, right? And you have to obviously your report, take down the testimony. And here you have, how would he even ask himself questions, right? Like, does he talk in the third person? Mr. Summers, where were you on blah, 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 blah date at such and such time? Okay, so Nikki, Trevor Summers, this is out of Florida. It's taking place in Hillsborough County, which encompasses Tampa. And what he is accused of is kidnapping his ex-wife, holding her hostage for days. And there's other charges too, but I'm not completely exactly sure. We'll find out at closing when the jury instructions are read, for sure, for sure. And this happened in 2017. And so up until this point, there's been a ton of like legal wrangling on Trevor Summers' part, right? He has hired attorneys, fired attorneys, gone pro se, then had an appointed attorney, and the trial actually started Tuesday of this week. Monday of this week was the jury, picking the jury. And Trevor initially wanted to have a continuation postponement because he said that basically because he is in the Hillsborough County Jail awaiting trial, he does not have access to witnesses, either the state's witnesses and the state's evidence, or getting his own, right? But he did, at least on Monday, have a standby attorney. Okay.
Everyone had a nice night. Yes, Mr. Marquise, thank you. Good morning. All right.
So let me just run through this real quick before we start. So he had a standby attorney on Monday when they were doing the jury selection. And then he changed his mind and agreed to let Mr. Marchese be his lead counsel. So the state was proceeding through their list of witnesses, and it gets down to the part where his ex-wife, which is his victim, is going to testify. And it's her second day of testimony. Okay. And they get to the part in the morning where they're going to take their morning break, and Mr. Marquez, and they're dismissed, and they're all rising for the jury. The jury leaves. Mr. Marchese's waving his hands, and he says, "Listen, Your Honor, Mr. Summers has just informed me he wants to dismiss me as lead counsel." So, the judge is like, oh, like you could just see it in his face. So there's like talking back and forth, and the judge is telling Mr. Scott, "Listen, I'm not going to go back and forth with you. If you do it, this is going to be for the remainder of the trial, yada, yada, yada." And so he ends up allowing Trevor Summers to represent himself for the remainder of the trial, which meant that he was able to cross-examine his victim, which was incredibly uncomfortable And yes, so that is what happened. I played a little bit of it last night, and the state has now rested. So this morning is going to pick up with the defense's case in chief, and he was supposed to be considering whether he's going to testify today or not overnight last night. So let's listen.
Let the record reflect everyone is present, including Mr. Summers. Good morning to everyone again. The first thing, well, we're going to get to in just a moment. Mr. Summers, I gave you the evening to consider your decision whether to testify or not testify. We're going to get to that in a moment. And we have some time because one of our jurors, I just want to let you know that number 7 is not here yet. That's the same gentleman that was late yesterday. But that's all right. We'll see. We'll address that as that'll be the last thing we address, and maybe he'll be here. The traffic was terrible. It took me twice as long to get here this morning. So I suspect that the traffic is probably the reason for that.
There's a wreck.
But the first thing that I want to address this morning is that I was advised by the clerk's office this morning that for approximately 1 hour last night, the evidence was left in the main clerk's office before it was ultimately moved to the evidence vault. The clerk's office, though, this morning has gone through all of the items of evidence with the list and has verified that all of the admitted evidence is, in fact, accounted for. So I just wanted, since they notified me of that, I wanted to notify you all of that same information. All right? All right? All right. So that takes care of that. The jurors here, which is great. So things are starting to fall into place. So now, Mr. Summers, I am going to turn to you and address you and your decision whether to testify or not. The first question, actually, I do have to swear you in if you'll raise your right hand because I have to ask you a number of questions.
Here we go.
Do you swear affirm any testimony that you may give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, thank you, sir. The first question that I want to ask you is, did you have the opportunity to consult with standby counsel regarding your decision to testify or not testify in your case?
Yes, Your Honor.
I guess he allowed him standby counsel. I'm so confused.
You have the absolute right to remain silent and not testify in your case. The other side of that is, if you wish, you can come down and testify as a witness, just as all the other witnesses have testified. I think I mentioned the procedure to you yesterday. I will follow the same procedure as all the other witnesses. You'll come in front of me. I'll swear you in. You'll take the stand. The only difference is, since you're representing yourself, you won't have someone else to ask you questions. So your testimony will be presented in a narrative form.
Look at Jen Lou.
Just talk to the jury. If at any time you are presenting testimony that the state believes is objectionable, they would then object, give me the legal basis for the objection, and I would make a decision as to whether you can continue saying that. The issues that may come up are relevance, hearsay, things like that. So much like the things that have come up with other witnesses. At the end of the day, it is your decision and your decision alone whether you are going to testify or not. My next question to you, sir, is, have you had sufficient time to consider this very important decision?
Yes, I have, Your Honor.
Have you made a decision?
Yes, Your Honor.
What is your decision?
I will not testify against
Has anyone forced you or threatened you in any way to reach this decision not to testify?
No, Your Honor.
Are you under the influence today of any alcohol, drugs, medication, prescription, or over-the-counter that may in any way affect your ability to freely and voluntarily make this decision?
No, Your Honor.
Okay, thank you. I appreciate it. Let me just see. State, did you have anything else that you want me to ask him regarding his decision?
No, Your Honor.
All right, thank you. Thank you very much, Mr. Summers. So that means that you need to rest your case. Again, I can't help you and I'm not helping you, but some of the procedural things that you may not be aware of, in order for us to move forward, I will let you know. That means that you have presented all of the evidence that you intend to present. Do you agree? Is that correct?
Yes, Your Honor.
All right. So that means that we are at the stage where you would rest your case. What I propose that we do, since all of the jurors are here, is that
No
I bring
worries,
them
Sam.
out. I turn
Glad
to you.
you're
I
here, babe.
welcome
Good
them.
morning.
I ask them if they've been exposed to the case, just like I've done every other morning. I then turn to you and ask you or tell you you may proceed. And then it would be time to announce the resting of your case. Then once you've done that, I will tell them that there are legal matters, because we then have to go over the jury instructions, the charging conference that I mentioned, and I asked you to read the instructions last night. So I would then explain to them that now that, well, let me just make sure. I would then, once the defense rests, turn to the state, who has the opportunity, if they wish, to request a rebuttal case. Is there any such request?
No, Your Honor.
All right, excellent. So knowing that, what I may do once he rests, I'll turn to the state. Is there anything else from the state? And you can say nothing. And then I'll tell them now both sides have rested their case. I have to go over the legal instructions and legal matters with them. I don't know how long that's going to take, and send them out. I know that now I don't know how long it's going to take, but I know it's not going to be super short. So I'll leave it up to the bailiffs if you want to let them go to the coffee shop or something like that and come back, since they're going to be in that room for a little bit of time. Is there any objection to that procedure?
No,
Just like when they take a lunch or anything like that, we'll tell them maybe an hour. It may not take that long, but I'd rather that we're done and waiting for them than they're back there waiting for us.
That's fine, Your Honor.
Do either of you think that an hour? I mean, I could say 40. Let's do 45 minutes. We have to print, so we'll tell them 45 minutes. All right. So they can go for 45 minutes. All right. Is there anything else from the state before I bring them in?
Nothing from the state, Judge.
Mr. Summers, anything from the defense before I bring in the jury?
Not at this time, thank you.
All right. Let's get the jury. Thank you. And I'll try very hard not to say ladies and gentlemen and then correct myself. It's only, the fourth day. Good morning. How are you? God, it's cold in here today.
Not yet. It gets colder though.
It's really cold.
By the afternoon, it's freezing.
I need it in paper, so if you can email it to. Yes, we are.
All rise during your courtroom.
I will say the courtroom has significantly less witnesses, not witnesses, spectators today than it did. Oh, well, maybe not.
Jury is present and seated. Everyone else may be seated at this time. Gentlemen of the jury, good morning and welcome back.
Yes,
I know it's a
basically,
little
Tia,
bit
we
later
wait.
than we had expected to bring you in. I do apologize for that. Take full responsibility. I also know that traffic was very bad this morning. I'm not responsible for that, but I was actually part of that myself in that traffic. But thank you
The
all for
traffic
being
is
here,
bad.
for being here safely. First thing that I need to ask you is whether any of you, by raising your hand and letting me know, were exposed to anything about this case outside of the courtroom between the time you left yesterday and the time that you returned this morning. Let the record reflect there are no hands. Additionally, I will ask whether any of you discussed this case amongst yourselves or with anyone else between the time you left yesterday and the time you returned this morning, by show of hands. Let the record reflect there are no hands. Again, thank you all very much. So you may recall that we left off yesterday in the defense case. I am now going to turn to the defendant and ask him to proceed.
Your Honor, at this time, the defense is rest.
All right. Gentlemen of the jury, is there anything else from the state?
Nothing further from the state, Judge.
All right. Gentlemen of the jury, each side has now concluded their presentation of the evidence in this case. You may recall from the initial instructions that the next phase is the closing arguments of the attorneys, the state, and the defendant. After the closing arguments is the instruction on the law. I cannot finalize or could not finalize the instruction on the law until all of the evidence was admitted. I am going to excuse you, and I am going to finalize the instructions. I'm going to, we're going to take a 45-minute break, and I believe it's my understanding that the bailiff is going to let you go to the coffee shop or anything you want and come back in, and we should be ready at that time and proceed to the closing arguments and the instructions on the law. Please be very careful not to be exposed to anything outside of this courtroom about this case and to not discuss this case amongst yourselves or with anyone else. Again, thank you all very much for your time, your patience, and your service. All rise for the jury.
Now let's see what happens. I mean, we know what's going to happen next. Obviously, he just told us, but I'm curious if we're going to get to hear what happens next. You know what I mean? The arguing over the jury instructions, which is going to be very interesting. I don't know. He was allowed to have standby counsel. So
Jury has exited. Everyone may be seated. All right. Both sides have rested. Mr. Summers, is there anything that you want to say or put on the record now that you've rested your case?
Your Honor, would you like to discuss the jury instruction of the abandonment purpose?
That will come. We're going to do a charging conference in just a moment. And yes, we will discuss that during the charging conference. But is there anything else that you want to, and if you want to lean over and talk to Mr. Marchese, I'll allow you to.
I do have a question about the, yes, pardon me.
Absolutely. Mm-hmm. I do that. Summers, was there anything else? You said you had a question, and I absolutely will get to that question. If you want to ask that question first, you can do that, or if there's anything else you want to do or say at this time.
I'll wait until we get to the jury instructions for that question.
Okay.
But I would, again, move the court for a verdict of acquittal. Your Honor, the defense moves for a verdict of acquittal for failure of the state to prove a prima facie case against me. On the first and second charge of premeditated attempted first-degree murder, the state has failed to prove any premeditation. And I add abandonment of purpose. The facts clearly show an abandonment of any attempts. The defense moves for a directed verdict of acquittal for failure of the state to prove a prima facie case against me on the charge of kidnapping. The state has failed to prove the purpose of the kidnapping was for grand theft. And the state has failed to prove any intent to commit the crime of grand theft, the alleged purpose for committing the kidnapping. And on the charge of grand theft, the state has failed to prove any intent to commit grand theft. On the two charges of sexual battery by a person 18 or older and upon a victim 18 or older, the state has failed to prove any intent to commit both counts of sexual battery by a person 18 or older upon a victim 18 or older. I thereby move the court for a verdict of acquittal, please.
All right, let me just give the state a brief opportunity to respond to the motion.
wow.
Judge, as far as to counts 1 and 2, the state has shown a prima facie case of premeditation. We clearly have testimony from Ms. Mathewson, who said as to count 1 that he came into the bedroom with the pillow, puts the pillow on her, then gets on top of her and proceeds to straddle her, applying more pressure. As far as count 2, testimony was that the defendant went from the front driver's seat to the third row, got behind her while she was tied up, claiming he needed to write a letter to his parents. And at that point, that's when he pulled the rope and was strangling her. There is no abandonment.
If you're just joining us,
Judge.
welcome, and please give your girl a thumbs up if you would,
which
please.
he intended to do is not abandonment. I have case law prepared, Judge. I'm ready to go ahead and just argue that if you would like.
Yeah, let's wait till we get to the attempt instruction, because that's part of the standard instruction on attempt that includes abandonment. So let's wait till the charging conference to argue that.
Okay. As far as to the grand theft, Your Honor, it is clear from the testimony that after Ms. Mathewson tried to run away at the Walgreens, the defendant ran out of the store, grabbed her, forcefully put her back into the car, and drove away from the Walgreens. There's testimony that for 2 days he was driving around Hillsborough County, Manatee County. That is evidence of him depriving her of her vehicle.
Let me just ask, I apologize for cutting you off, but when you say things that I want clarification on and not sure that I understand, is it your position that the depriving of her was related to the Walgreens and not when they left the house, or that when they left the house, but somehow what happened at Walgreens? I just didn't understand. Go ahead.
Yes, Judge. Starting from the house, because we have testimony that he tied her hands behind her back, puts a blanket around her shoulders, puts her in the back seat or the second row. He's the one who got the car keys. He's the one who drives, and per his own statement with Sergeant Remia, drives to the Walgreens. And then it continued from there. We even have his statement to Sergeant Remia, or what he says to Miss Mathewson is that we can't go see the kids now because of her trying to run away. And at that point, proceeds to drive around Hillsborough County, down to Manatee County, Anna Maria Island, finally ending up 2 days later in Little Harbor.
Wow.
And the jury instructions as far as a grand theft of a motor vehicle or obtaining or endeavoring to obtain means either permanent or temporary. And in this case, we have 2 dates, Judge.
Okay. What about the other, I mean, well, if you want to respond to the kidnapping, but the sex battery?
As far as the kidnapping, the state's relying upon all the testimony provided. There's an independent witness who saw it happen. Lastly, as far as the sexual battery, it's up to the purview of the jury to decide whether there was consent or not.
Right, but specifically, what evidence are you contending is enough to get past this stage and be presented to the jury?
The fact that he snuck into the house in the middle of the night, he wakes her up, her testimony being that he grabs her by the ankles, pulls her off the bed, an argument, struggle ensues in the living room. Ultimately, once the kids are gone, she's tied up in the bedroom. All of those acts that the defendant took carry along with Miss Mathewson's testimony that the sexual act that took place against her was not consensual.
Thank you. Mr. Summers, any brief response to anything that the state has presented at this time or argued?
Yes, I continue my standing objection to the statement made in the hospital. I do concur that that was something that was not voluntary. And but however, Honor, if they're weighing on that, there are other statements I made in that interview where I never said I intended to kill somebody. I never even mentioned strangulation, if they're relying upon that. Nor do I mention desire or intention to steal a vehicle. I speak about it as a common item that we share, that we use. And I also speak about the sexual encounters as casual. It is something that is a common thing between the victim and I at that time and prior to that. And the victim herself stated that sex doesn't mean that much to her.
I mean, that doesn't mean that someone who is of that position can't be sexually battered just because sex doesn't mean that much to her.
I understand, Your Honor. And I'm explaining to you as best I can without testifying as to the situation at the time. But I can.
I thought that they
just
did
assert
non-stop,
that,
Mom.
None of my statements have, whether recorded or not, have led to there to be any belief that that I intended to do that out of coercion, out of desire, out of anything other than just something that her and I agreed to do to pass the time. And aside from that, Your Honor, again, the vehicle, there is no evidence of me needing that vehicle, requiring that vehicle. She attested to the fact that when we go out, I drive. Again, Your Honor, I have not attested to these facts. That the only things they're relying on are in a statement that I, again, have objected to. And I would also object to their statement that Ms. Summers or Ms. Mathewson stated that I brought a pillow into the room because I don't believe that was presented in the testimony during this trial. I believe that is a statement she made in a previous recorded proceeding.
That's what
not
I thought,
during
but
this.
hold on, nonstop,
Well,
Mom. I
that's
don't want to
ultimately
interrupt
certainly
him.
something that you can argue to the jury, and I will instruct the jury that they rely on their own recollection that what you and what the state says during closing arguments is not evidence, but that they are to rely on their recollection of the testimony. So that's the issue may come up there. But what I want to understand right now is it appears that your legal position is that you never intended to commit the crime of, I guess, murder, and that you never intended to commit the crime of kidnapping. I mean, that's, I think, what I heard you say. Is that correct?
Correct, yeah. There is no intention from her statements or my statements.
Okay, and that is certainly an
Hold on, I'm
argument
gonna
of
pause
defense
him
that
real
you can
quick.
raise and
Okay. Hold on a sec. Okay, so when we watched the victim's testimony yesterday, she did make a mention of being examined. She said she was thoroughly examined. Now, the question that he asked was related to the duct tape, if she were tested for any adhesive around her mouth. But she went to the hospital. And so I'm very curious, and I was waiting for the state to say, but we have, medical evidence, and they didn't. I'm blown away, you guys. And normally, you know me, I always have tons to say. All right, here we go.
argue to the jury. But my question to you, it's about to come up in the instructions, is how can you abandon something that you never intended to do? You see what I'm saying? I mean, do you understand that? If my position is I never intended to touch that book, then how can I argue that I abandoned? What did I abandon if I never intended? You abandon your lack of intent to touch. I never intend to do something. How do you then argue that I abandoned? What are you abandoning if you never intended to do it?
Your Honor, again, I believe that goes to the legal argument, and if you'd like me to cite.
But your legal position in your motion is that I never intended to do it. I just said, it sounds to me like that's what your position is. Is that your position? And you said, yes, it is. I never intended to do it. So, and I said, and we will, I'm going to deny your motion for a judgment of acquittal at this time. But now we're going to move to the jury instructions. And when we get to the abandonment, I'm curious to see what you say, because now you're going to argue that I don't know what you abandoned if you never intended. So,
may I answer that?
Sure,
one
absolutely.
question for you?
Yeah, I'd love to hear it.
Yeah, I'd love to hear it too. We'd all
In
would.
my own statement, I never intended to commit murder or intended to murder her. I never intended to kidnap her. But in addition to that non-intention, I add to that the defense of abandonment based on her statements that both times she says, I just stopped. And that is where I add in the
But you can't
factor
have
of
both.
abandonment of purpose.
So tell me exactly what you're abandoning.
Abandoning the process of attempting to kill someone.
Process of attempting to kill someone
Jesus,
when you never had any intention to kill someone. Is that a correct statement?
Yeah, because in the first place, I didn't have the intention. And then the intention is derived by the victim's understanding, not by me admitting it, not by my own desire, not by my own actions. a variety of other reasons why things could have happened according to the way she says they happened. They don't have to all lead to the attempt to murder.
It just appears to me, at least at first blush, that those are separate defenses. Didn't intend to do it, so I'm not guilty of it. I intended to do it, but
I stopped.
I abandoned my process of doing it. Are separate
Yes.
defenses
Correct.
that are mutually exclusive of
Yes,
each
they
other.
are.
I understand what you're saying, Your Honor.
Okay.
I'm giving you the.
I
the
understand
fact
what
that
the
there is no
argument
intention,
he's
and there's no
trying to
proof of
make.
My intention. It's only her perceived feeling. There is no proof.
So this is what he's trying to say, okay? So he's trying to say that I never intended to unalive her, okay? And that the proof of that is that I stopped when the pillow and the rope, right, were part of something completely set, that they were not part of an attempt to unalive her, right? This was part of something else, and that he's attempting to show the fact that he stopped strangling her and he stopped smothering her with the pillow as intent, right? That obviously if I intended to unalive her, I would never have stopped. And therefore the stopping is showing a lack of intent. But in a legal sense, they are completely two separate, mutually exclusive legal arguments. So you can't argue both. No, the jury, I don't think no, the jury has been dismissed. They're not listening to this. That is what he is attempting to argue, but it's not, you can't, as the judge is saying, they are two mutually exclusive legal arguments. So you can't argue lack of intent and abandonment at the same time. But I understand what he's trying to say. This is where you need an attorney.
Of that intention.
And you're welcome to argue that to the jury.
Right.
But that's a defense. But then to also be allowed to argue that I abandoned, I just don't see how you're going to do that. I never intended to do it. However, I abandoned my attempt to do it.
And again, Your Honor, that's the legal argument that is available to me to bolster
It's not
my.
always available. It's available if there's evidence of it. I tell you what, I understand. Absolutely.
This is a mess.
Let's start with the jury instructions.
No, the
and then
jury's
we'll get to
definitely
that
not
in
listening
just a
to
moment.
this.
Okay.
All right. Go ahead, have a seat.
Thank you, Your Honor.
Uh-oh. I need my copy. Do you have a copy of the full instructions? Mine's on my desk. Thank you. My staff attorney has the instructions up, and it's just easier if she makes any changes that we discuss, because she can print them directly rather than waiting for an email that sometimes takes forever.
Excuse me, Your Honor.
Printing them.
I'm
So
just
we've
going to
learned
turn you
a few
down
things over the
because
years,
I don't want to be rude.
and it's just quicker
Okay.
if she makes the changes and prints them directly.
So, Amelia,
I will, of
Mr.
course,
Summers has
give you all
elected
copies of
not
the printed version
to
so that you can
testify.
verify
Now
any
we're
of the
going to
changes
move
that we
to
discussed
the
and
arguments
agreed
for the
upon
jury
are in fact
instructions, right? And
what's been handed to
everyone
you
is
was
very
my proposed,
confused. I can't talk over this judge.
consolidation.
I'm so sorry, Your Honor. I just don't want to interrupt you, but I have to. Okay. So basically, we're at the point where both sides have rested. Okay. The jury has been removed, dismissed, and on a break, and they're going to argue now over jury instructions. However, Mr. Summers has made a motion for acquittal. It was denied, but the basis of his motion for acquittal on all of the charges is that, oh no, babe, you're fine, because this is just, they're just ironing out the kinks. And so this the basis for his motion for acquittal is lack of intent and simultaneously abandonment, except for their two separate legal arguments. And so and he's not a lawyer, So he's not arguing effectively. I understood what he's attempting to say, and I think that the judge does too, but you have to go by the law. Basically, what Mr. Summers is saying is the fact that I stopped smothering her with the pillow and stopped choking her with the rope, that would be the abandonment, is evidence of lack of intent. That's what that's what he's asserting. It's but it's bullshit. Because, I don't know, but here we go. We're gonna get into it. Good morning, Chick Tracy. It's good to see you, babe.
Counts.
Also, I would like to motion that due to the fact that I was able to figure out that when somebody is representing themselves and simultaneously potentially going to testify, that means that it is a narrative and that the state would then raise objections during said testimony. And I was correct that I should start a PayPal pool and go to law school. That's what I think. Just kidding. But I am rather proud of myself for thinking of it.
And an 8 into 1.
I'm being right.
Instruction on neglect of a child. So just so you know what it is and you can start looking at it, we'll insert it into the stack where it goes. And then I just want to go orderly through each one and we'll be able to discuss it. But since it was handed to you, I want you to know.
Oh, let me turn him back up.
Judge, it needs to include count 9, though.
6, 7, 8, and 9.
Yes.
GS. Okay.
All right, we'll make that change.
Yeah. Well, let's get.
Yeah, I'm not saying I'm giving it. We're going to talk
Yeah,
to
I
it.
was gonna say,
We're going to
let's
talk
do
about it. We may end up doing them all separate. I'm
Mr.
sorry,
Summers, you only
You were
stand when
standing,
you
so did
address
want to ask something
the court.
or say something?
No, same comment.
Okay. Thank you.
Just so you know this.
Remember, I can pull it.
I am rather
What I
proud of myself,
instructed
though.
them-
That
what
was.
what's happening now, Mr. Summers, is
I'm
the
smart.
formal
Oh, I need more
instructions
coffee.
on the law can either be given before the closing arguments or after the closing arguments. Traditionally, it was always given after the closing arguments. Sometimes attorneys come in and request
thank
that it
you,
be done
Chick
prior
Tracy.
to. I honestly don't care.
But
whether I read
I'm
all
45
of the
now,
substantive
and if
instructions
I
on the law
started
before
today, I'll
the
be
closing arguments are
46 in
given,
January.
or after. I have no preference.
If I started today,
But
I'd be like,
there is
I
an
don't know what,
initial
52
instruction in the
before I could
beginning
start actually
It tells
practicing
them
law.
how we're going to do it, and that's what I want to go back and look at what I instructed them.
Your Honor, if you read what was provided by the state, you had stated to the jury.
I have it. Let me read it
Okay.
because this is the actual instructions that I read from. What I read was after the evidence has been presented, the attorneys will have the opportunity to make their closing arguments. Following the closing arguments by the attorneys, the court will instruct you on the law applicable to the case. After the final instructions are given, you will then retire to consider your verdict. So I told them that you're going to do closing arguments, and then I'm going to give them the final instructions. Is there any requests now that after I've informed them of that, to proceed otherwise from the state,
I defer the court, Judge.
from the defendant?
I would defer to you.
All right, I'm going to do then what I told them I'm going to do in the initial instructions. Thank you all. I appreciate that. And that was the easy answer. I told them one thing, and I hate to change. I'll change as few things as I can about what I told them.
No, he's not to, he can't drag his lawyer back in it, but the judge was,
So, as if they
is
were going to be given
allowing him to be
before
standby to
the
ask
closings.
questions,
So
but
the
that's it.
initial said that they were going to be given after, but there's something in them now, I'm being told, that indicates that they are given before.
What?
3.1 right now says both the defense and state defense have rested their case. Please pay attention to the instructions I'm about to give you. You need to start with closing argument.
All right, so
Just give me 2 seconds.
Yes, Judge. I went off of instructions from Judge Kaiser's courtroom. I know that multiple judges like to do instructions first, and then do closings. And I wasn't aware of what your honor's preference was, so I had just utilized what we typically do in Judge Kaiser's.
And that's absolutely not a problem. But the problem I have is
I've already fixed it.
that the instructions that were presented, you heard what I read, right?
Yes, your honor, I had prepared these last week. Yes.
So,
All right.
So now your first instruction will be 2.7, which is all the way in the back of that packet. So,
Bless it. I'm going to refill my
2.7.
coffee. I'll be right back.
The pages stick together for me. There we
Y'all
go.
behave.
All right, and we put that at the top. So page 60 will actually now become page 14. Mr. Summers, were you able to find that?
Yes.
All right. This is not a big deal at all, but the language is slightly different depending upon whether I do the instructions before you do your closings or after you do your closings. So 2.7, closing argument. It's the introduction to closing argument. Mr. Summers, is there any objection to it?
No.
All right. So next, I would have 3.1, introduction to final instructions,
and you will not read the first sentence.
and I'm scratching out the first sentence, and we're fixing that as I speak, unless someone objects. State agree? Scratch the first sentence. Mr. Summers, you understand and agree? I'm going to scratch the first sentence.
Yes, Your Honor.
All right, so then I'm going to read, members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions that I'm about to give you. That is, so just also so you know, after I read 2.7, you all are going to present your closing arguments. The state's going to go first, then you're going to have an opportunity, and then the state has an opportunity for a rebuttal. In fact, that's in the instruction. It says that. So then after those closing arguments have been presented is when I'm going to turn to 3.1 and say, please pay attention to the instructions I'm about to give you. The next instruction I have is 3.2, statement of the charge. Mr. Summers, have you read it and do you agree with it?
Yes, Your Honor.
Thank you. I just like to also look at it myself. I've done it both ways, where it says defendant in this case has been accused of the crimes of attempted murder in the first degree. We don't have to say how many counts. That's fine. All right. Next, I have 6.1, introduction to attempted homicide. Is this the one that the standard has the option of abandonment?
Every thing that has attempt
Has the option.
Yes.
All right. So this is where, Mr. Summers, we're going to have to revisit. First off, have you looked at 6.1, introduction to attempted homicide?
Yes.
It would really be in 6.2 though. Sorry. Is where I would think you would add it.
All right.
Because that's just like the generic.
Any objection to the introduction to attempted homicide 6.1? All right. Next is 6.2, attempted murder, first degree, premeditated. And this is where in the standard instructions, there is actually an option for including abandonment. Is that correct?
Judge, the abandonment language is not in the standard instruction of 6.2. The abandonment language is under 5.1.
Okay. All right. Well, then let's wait till we get to 5.1 to discuss it, because I don't want to deviate from standards. And if I'm going to give, as is at least right now appears to be requested, any abandonment language, I want to use the standard instruction on it.
Judge, the state did not include 5.1 because, again, it's the state's position that he's not entitled to the defense of abandonment.
Okay. So this is the idea of
Yeah.
adding 5.1.
Correct.
Yes.
Because 6.2 is the standard instruction for attempted murder, first degree, premeditated. In other situations, Your Honor, you would have the regular jury instruction, say for a sexual battery. You would have the jury instruction for sexual battery, but you would include 5.1 before the reading of the standard instruction for sexual battery. The Florida Supreme Court created the standard and jury instruction for attempted murder by itself. therefore not requiring the additional instruction of 5.1.
Mr. Summers, what, if anything, is your request regarding these issues?
Your Honor, I would request that 5.1 be included with the packet. I do have a copy of that statement, abandonment of purpose. And if you would like to discuss that now.
Yeah, we are. Is that the same? Mr. Marchese in the beginning had handed me, and I don't know if it was 5.1 or if it was something that was different, but
Judge, he's providing just an excerpt from the statute. Has not provided the standard instruction for 5.1 that includes the defense of abandonment. And I also have case law that I can provide to the court for the abandonment issue.
well, go ahead and tell me. This is when we're arguing. This is where we're arguing. He's requesting. You are still requesting abandonment, even though you previously indicated to me that your legal position is you never intended to do it. Is that correct?
Yes, I'm still requesting abandonment of purpose.
Okay. So let me hear the state's response to his request, and then depending on how I decide, we'll decide where the language is going to come from, if it's going to come from anywhere.
Judge, may I approach for some case law?
Yes, and please provide Mr. Summers
Yes,
copies of anything you provide to me.
I think I need to get the staples out of the paper, Judge.
Oh.
Yes, she does.
I think there's some up here, if not over there. Probably should take the staples out of mine in the future too. I'm sorry, Mr. Summers, you're not allowed to have staples.
Well, first, Judge, the state would argue.
Let me just make sure he has them. Mr. Summers, you have, there's 1, 2, 3, 4, 5 cases. Do you have those cases?
Yes.
All right, Ms. O'Connor, you may proceed.
First and foremost, Judge, the defendant has already stated during his previous judgments of acquittal that he did not intend to commit the premeditated act of killing Miss Mathewson. That alone, in and of itself, does not allow for an abandonment defense. As Your Honor has already pointed out, how can you abandon something you did not intend to do? Secondly, the case of, which I apologize, I did not have a copy of this one printed out for everybody, but it's Carroll v. State, 680 Southern 2nd, 1065, 3rd District Court of Appeals from 1996. And in that case, the court distinguished between voluntary abandonment,
Right.
which
I'm
is
familiar
allowed
with
by
that.
law as a defense, and involuntary abandonment. It goes on to describe involuntary abandonment when the defendant fails because of unanticipated difficulties in carrying out the criminal plan at the precise time and place intended, and then decides not to pursue the victim, or when the defendant withdraws because of a belief that the intended victim has become aware of his plans, or because he thinks that his scheme has been discovered or would be thwarted by police observed in the area of the intended crime.
That's involuntary, and that is not a defense.
That
That,
is
under the
correct.
case law, is not something that he would be able to argue.
That is correct.
However, voluntary abandonment, how does that case describe voluntary abandonment, which is a defense?
Voluntary abandonment is a complete renunciation of any intention of committing the crime. So in this case, it would be a complete renunciation of committing the attempted murder, of attempting to kill Miss Mathewson. I provided Dixon v. State, which is 559 Southern 2nd, 354, 1st District from 1990. And in that case, Judge, the court held that once the crimes are committed, as soon as an attempt was effected, the defendant was not entitled to the abandonment defense.
Which case was that? I apologize.
Dixon v. State,
Dixon, I got it.
that case is exactly what we have here, Judge. The defendant committed and attempted to commit by putting a pillow over Miss Matthewson's face, then getting on top of her, putting more pressure on that pillow to the point where she actually loses consciousness. His own self-serving statements and his post-Miranda interview with Sergeant Remia is not sufficient to allow him to have the abandonment defense, because he has already, and even in his own statement, admitted that he effectuated the crime. As far as the commission of the strangling for count 2 with the rope, the state's position is that we have testimony that his actions were thwarted because he believed he saw an undercover police vehicle. That is involuntary abandonment. Therefore, he is not entitled to the affirmative abandonment defense for either count 1 or count 2. The courts have even addressed this issue with felony murder cases. And the courts have cited and stated, even if the actual or the defendant was not included or took part in any way of the murder, if that defendant took part in the underlying felony, they were not entitled to the abandonment defense. That is cited in or discussed in Smith v. State, which I provided 424 Southern 2nd, 726. Supreme Court of Florida, 1983. Kane v. State, 698 Southern 2nd, 1254. A second district court from Second District Court of Appeals case from 1997, as well as Miller v. State, 503 Southern 2nd, 929. A third district court of appeals case from 1987. And in that case, Judge, I'll note that the court considered the defendant's self-serving statements to the police, where he replied upon his innocence. And we have that situation here, Judge, where the defendant is relying upon his statement.
I'm glad we get to hear
Where
this.
he is saying that he didn't intend to kill her, and therefore he should be entitled to the abandonment defense. So for all those reasons, Judge, it's the state's position that the defendant is not entitled to the affirmative defense of abandonment that would be included in the standard instruction of 5.1.
All right, thank you, Ms. O'Connor. Mr. Summers' response.
Yes, Your Honor. Quoting Longbow v. State, which is the case that you had mentioned earlier.
Right. Yeah, I think I cited 2 cases to take a look at on the abandonment defense. So go ahead.
It states that a defendant is entitled to have the jury instructed on the rules of law applicable to his theory of defense if there is any evidence to support such instructions, no matter how flimsy that evidence might be.
I agree. Well aware of that proposition of law.
And then it says, in determining whether to give a requested instruction, the trial court should consider the evidence presented without weighing it. Ask the latter if a task for the jury. And so that puts it to the jury to decide if there was an abandonment of purpose. Additionally, Your Honor, in
So let me
according to
translate
the
this for you
instructions
guys.
on Crimes,
Please hold.
I'm quoting from
You're-
the criminal laws and rules.
Stop. All right. So basically, what he's saying, his argument, excuse me, for the abandonment issue is basically, just let the jury decide. Stick it in there and let the jury decide whether or not I abandoned the crime.
2012 jury instruction in criminal cases. I'm at
What was the rule? I'm sorry.
defense rule section 777.04 5A Florida statutes.
All right, go ahead.
It says it is not an attempt to commit crime charge if the defendant abandoned his or her attempt to commit the offense or otherwise prevented its commission. under circumstances indicating a complete and voluntary renunciation of his or her criminal purpose. And, Your Honor, again, I have not testified
Thank you, Amelia.
to trying to kill anyone. The evidence only shows the statement by the victim, the involuntary statement by myself. Both show that a pillow was put over, but it doesn't say to kill her. In my defense, it doesn't say it's to kill her. It could have been to just keep her quiet. It could have been for something we were doing in the bedroom. But the intent to kill somebody has to be easily recognizable. Just because of a look on my face doesn't mean that there's something in my heart that says that's what I intended to do. And there's no statement by me saying I intended to do that. It's only an impression. And it's so the circumstances don't meet the threshold, don't rise to this level of attempting to kill someone. And in that manner, if I didn't intend to do it in the first place, I abandoned any further effort to actually commit that crime.
See, what I hear you saying is there's absolutely no evidence of your intent. Well, the very first element of 6.2, number 1 is, it says to prove the crime of attempted first-degree murder, the state must prove the following 3 elements beyond a reasonable doubt. Number 1 is that Trevor Stephen Summers did some act intended to cause the death of Elisa Summers. So that's your defense, that they haven't proven that you did anything to intend, that you had no intent, that they can't prove intent. I don't understand why you want to argue abandonment when you're saying that in order to support that, there's no evidence that you intended. And that's the exact argument or attack on the elements of their claim. They have to prove you intended.
I understand. And maybe the best way I could explain my understanding of it is this: a moment in time where a decision is made from messing around with a pillow to intending to kill somebody. And maybe it was Mrs. Mathewson's impression that at that moment in time, that split second, she thought she was going to be killed. At that moment in time, I thought this could go further, but I didn't. And so I guess I'm pointing to that moment in time when a decision could have been made to be much more severe. And at that moment in time, that decision to, or that potential decision to go more severe was abandoned.
Meanwhile,
Anything else?
hold on, let me push pause.
No,
So
Your Honor, those are
the irony here, in my opinion, is the argument of a split second moment in time, right? Because there is no time limit or explicit amount of time under the law for premeditation. It can be 1 minute, 1 second, 1 hour, 1 year for premeditation. So this is interesting to me that this is his argument, but let's keep hearing.
the ways that I've been able to consult with Mr. Marchese about. That's the best I can explain. I understand it. And I do believe it has some merit.
I thank you, and I appreciate your argument and your position. I will say this. I only make rulings that I believe are not going to be reversed by the appellate court. So I believe that I'm right on my ruling. But I caution the state that if the appellate court thinks that I'm wrong, probably one of the most common reasons I have seen retrials is the court's denial of a requested defense instruction on the law. And the appellate court says you should have given it. I'm not giving it. I'm ruling in your favor because I think you're right. But most of your argument is that it's a crazy defense and there's no way, which are all things that if I gave the instruction, you could argue to the jury, even though there's just absolutely no abandonment. And that would eliminate any appellate issue of the appellate courts then saying you should have given the instruction. I'm not giving the instruction unless you concede to me giving the instruction, because I think I'm right. I think you're right. But the important part of that sentence is, I believe.
You never can
that we are-
tell
You are right. And I believe
what an
that
appellate
he's not entitled to the
judge is
instruction.
going to think.
But there's no question if you prevail and he is convicted, that's going to be one of the top appellate issues. And that's the only reason that I say that. So, Ms. O'Connor, it is my intention at this time not to give 5.1 attempt abandonment unless you change your position.
Judge, it's the state's position that the defense's argument is that the state has failed to prove beyond reasonable doubt element 1, that he intended to cause the death of Miss Mathewson or Miss Summers during the dates of these offenses. And for that reason alone, he should not be entitled to the abandonment defense.
Okay, I'm not going to give the abandonment defense. I think there's also the other issue that's going around there about I just don't think that you can argue lack of intent and also abandoning something that he never intended to do, just so the record is absolutely clear on the reasons, both reasons, that I am denying his request to give the instruction. So with all due respect, Mr. Summers, I'm denying the request to give an abandonment instruction.
I understand. Thank you, Your Honor.
You're welcome.
Okay, so we're just on 6.
6.2 as is, there won't be any instruction given prior to or any addition to 6.2 other than, and you're not waiving your objection, it is perfected for the record or your request and my denial. Other than that, any issues with 6.2?
No, Your Honor. I do maintain my objection.
Absolutely.
We got it. You've objected.
It is preserved for the record on appeal. 3.3 is what I have next. Aggravation of attempted first-degree murder by carrying, displaying, using, threatening to use, or attempt to use a weapon. Any disagreement, Mr. Summers? Any suggestions or issues?
Yes, Your Honor. I have a
Here we go.
question of the definition. Is it both 1 and 2 or 1 or 2?
I'm sorry. Where? Oh, as 2 counts 1 and 2. Yes, both.
Okay, and the weapon is defined as both. Is number 1 an object and so forth, or number 2 an object or so forth?
That is correct.
Thank you.
You're welcome. Any other issues, questions regarding 3.3a?
No.
All right. Next, I would give 9.1 kidnapping, which is as 2 count 3.
Holy moly.
Issues regarding 9.1 kidnapping?
No, Your Honor.
All right. And you do see, I notice now, because element 3 says that Trevor Stephen Summers acted with intent to commit or facilitate the commission of grand theft motor vehicle. Right under that, it says, see the definition for grand theft motor vehicle, which is in count 10, which we will ultimately get to. So it's actually instructing them to go forward to count 10 to see the elements of grand theft motor vehicle. You understand that?
Yes.
And have a problem with that? Okay. Next is 11.4 sexual battery. 4 elements. And we have to eliminate at least the italicized give if requested.
I was just waiting to see if they requested.
Is the state requesting that?
Yes, Judge, we are.
So, Mr. Summers, do you have any comment on that? What they're requesting, that line after give if requested?
Yeah, I would ask that be removed.
Removed?
Yes.
Do you intend to argue that? Is that, I mean, what it says is that her lack of chastity is not a defense to the crime. You intend to argue that the defense is her lack of chastity?
I'm
Honestly,
sorry.
Your Honor, I don't see the relevance, but that's just my.
It's part of the standard, and the instruction says give if requested. The state is requesting it, so I am going to give it. But we're going to eliminate that language that says give if requested.
Yes, Your Honor.
All right.
Thank you.
You're welcome. Next, I have 16 points.
This is the one where the proposed.
Oh, okay. So I don't have it on mine. This is
It's
the
that.
one we handed out. Yeah, thank you. Where did I put that?
This is
There it
just,
is.
you guys,
I've already added count 9 to that.
I can't.
Okay. All right. So what I am proposing here, if you look at 16.6 neglect of child on page, in this stack is 23, then you would have on page 24 also 16.6 neglect of child. Then after that, another neglect of child. Then after that, another neglect of child. Then after, so that's the total. The only difference in all of those instructions is the initials of the child. So what I've proposed and what was handed out prior to
Oh, boy.
court beginning this morning is 16.6 neglect of
Non-stop,
child,
Mom.
but in paragraph 1, including all of the different initials. So it would read as follows, just for the record, and we'll put a copy of it in the record and we'll see if anybody has any objection. Trevor, number 1, would read, Trevor Stephen Summers willfully or by culpable negligence failed or omitted to provide A.S. count 6, L.S. count 7, and or B.S. count
It'll be BS count 8 and or GS count 9.
Okay. With the care, supervision, and services
This whole
necessary
thing is
to
BS.
maintain AS count 6, LS count 7, BS count 8,
and or GS.
and or GS count 9, physical or mental health. And then in 2, it says Trevor Stephen Summers was a caregiver for AS, LS, BS, and it'll say and or GS.
These are all the children's
Same
initials,
with
obviously.
Count 3. So same theme here. It'll be AS count 6, LS count 7, BS count 8, and or GS count 9 were under the age of 18 years. Does everyone understand that consolidation into one instruction?
Yes.
Thank you, Mr. Summers. State.
Yes, Judge, I just think that, and I don't know if maybe I know there is a instruction that you need to consider each element separately and distinctly from each and in every other count. I don't know if we need to maybe add something that they are going to have to make the determination as to each element, as to each victim. It's on the verdict form and clear, but because we're putting it together, I don't know if we need to add any language.
I tell you what, we're going to spend more time talking about it than me reading. It's a half a page instruction 4 times, so I'll just read it 4 times. So forget what I handed out to consolidate. 16.6 count 6 as to AS. Any objection, Mr. Summers?
No, Your Honor.
Next is 16.6 neglect of child count 7 as to LS. Any objection?
No.
Next is 16.6 neglect of child count 8 as to GS. Any objection?
Yes. I need it to be corrected
To BS.
to BS.
Indeed.
Yeah.
BS
Judge, did the court
indeed.
consider-
Wait,
Hey,
State, do you
Jody.
agree that it should be corrected to the correct
Good to see you,
initials
babe.
of
How
the
you
child,
doing this morning?
As to count 8, yes,
which is instead of GS, BS.
correct.
All right, I just want to make one change at a time. If we all agree, my staff attorney can make that change. So GS is being changed to BS. Now, Ms. Johnson, you had something else.
Once you read the entire instruction as to count 6, I don't know if the court would want to say,
I
the
appreciate
further
you guys all
definitions
hanging in
given,
here
I've-
with me because
I
this
read
I
to you
find to be
previously.
fascinating.
Okay,
They can still be there.
The
on
arguing
form, but you don't
of
have to reread
what the
them.
jury
Neglect
instructions
of a
should be and
child,
why
care
they
of
should
a-
be that.
The definition for caregiver.
Because this is
and
the
definition
important
for
part,
culpable-
you know?
culpable negligence when you read 7, 8, and 9.
Maybe that's just me.
Yeah, let's just stick with the standard and abundance of caution. I appreciate that, but if I'm not going to consolidate them into one, I don't want to do something
And I also like the
to
way that
deviate
the
from the
judge is
standards, so.
thinking about
Go back
moving
to
forward
the one where we made the
with
changes.
potential
that was
appeals
count 8.
and,
Now says BS.
you know,
Other than that, Mr. Summers,
trying
any
to avoid
questions, issues, objections?
that.
Next, I have
No
count
judge likes their
9,
rulings overturned
which
on
is
appeal.
also 16.6, neglect of child, and this one is now GS. Any objections?
No, Your Honor.
All right. Next, I have 14.1,
Like, I know if it was
grand
me,
theft
I
motor
wouldn't.
vehicle, which is count 10. It is 1 page, full page long. Mr. Summers, any issues, objections, questions?
No questions, no objections.
Thank you. Next, I have, well, you know what? Just to be for the record is clear, you said no questions. Any objections?
I said no questions, no objections.
Oh, I'm sorry. I didn't hear the second
Oh.
part. I appreciate that. Thank you. Next, I have 8.18, which is as to count 11, violation of an injunction for protection against domestic violence. Mr. Summers?
No issues.
All right. Next, I have 3.4, when there are lesser included crimes or attempts, and specifically the lesser included crimes that are indicated in this instruction for attempted first degree murder are attempted second degree murder, attempted manslaughter, attempted aggravated battery,
Ooh.
and attempted battery. There are the lesser crimes
Already
indicated in the
Saturday
definition
over
of
there in the
kidnapping
land down
is false
under.
imprisonment. The lesser crime indicated in the definition of sexual battery is battery. And finally, the lesser crime indicated in the definition of child neglect is culpable negligence. Any questions, issues, or objections to 3.4?
Not for me, Your Honor.
The other day, I watched.
I accept that there's none from the state since it was what the state proposed. So state, that's why I'm not asking you to chime in unless you would like to.
I watched a video the
Next,
other
I have
day of
16.1,
a woman
introduction to
rescuing
attempted-
a koala bear from the
6.1,
fires.
introduction to attempted
Bless her heart, you
homicide.
guys. It was just
It is
the most
one
one of the
page,
most
full
heroic
page,
things
and then
I've
goes
seen. She
over
took
to
her
2
shirt
lines
off
and a portion
and
on the next page.
swaddled this little
Mr. Summers?
koala
Just a
bear
question,
up
this is required
in
to
her
be
shirt
in
and rescued him,
Sorry,
climbing over like
State,
not
why is it in
like a
here twice?
wire fence, not
Says
like a
in the
barbed wire fence,
instruction,
but like one of those
um,
farm fences. I just
that
thought
it needed to be offered.
I thought it
again,
was
but if
so
you want to say, please refer to
cool and sad at the
6.1
same time. That little
for,
koala was so
the
scared, bless
introduction to attempted
his or her
homicide
little
before you
heart.
read it's on underneath the list of the lessers. Down at the underneath the box, it says you need to reread the introduction to attempted homicide. But if you want to just put a line, see instruction 6.1 prior to attempted first degree murder.
Oh, you saw it,
That's the way
Chick
I've seen it
Tracy?
before. I
That's
mean,
fine.
that's pretty common.
I
was
would
just
do
trying
it.
to have more. It's
I
easier
would
to
do
take
it.
out than to add.
I would take a
Yeah.
bite, a
I have an issue
scratch,
with that, and that's why we
even
have this charging
potentially
conference and can discuss and
the
that's,
the
can you make that
the
change?
heat from the fire and any smoke inhalation. I would do it. I would rescue an animal if I saw it in need. I've tried many times to rescue other, help when I can.
Above it,
I think it's our
somehow.
job. It's our duty.
I can leave the 6.1 heading and say, please refer to.
I just think koala bears are so stinking cute.
And
I
that
can't
sounds
take it.
familiar, so I think that I've seen. So
Ever
Mr.
since,
Summers, you actually suggested or asked why it's in here twice.
I was
So what
on
we're doing now
Better
is,
Call Tour,
proposing
and she
to
was
take it
showing
out the
that
second
video
time, simply put
of the two
put
koala
the
bears.
seed the other time.
They were in a neighborhood. They were in a neighborhood and they were in a tree. And the one koala bear evicted the other koala bear who was also
Yes.
napping
Okay.
Yeah, and you're all
in
right
the
with that?
Yes.
in the
State's
tree,
all right with
out
that?
of the tree. And
All
that
right,
little
so I'm taking
koala
that
sat at the
6.1
base of that
and,
tree and just
putting it in
cried.
the,
It was like a toddler having a tantrum, and it was the cutest thing I've ever seen.
6.4 attempted second degree murder, and this is the lesser as to counts 1 and 2. It
I'm a little
is-
bit behind on this.
It goes on to the second.
Let me see how far behind I am.
What I'd like to, if we can,
About
I don't
8
like the
minutes
spacing where I have it.
behind.
Oh, okay. So
And
there
I don't
may be
even
some
know how long
reformatting.
they've
If
been
you see the
haggling
one
this
you
over. They
have,
gave it
the-
45
in
minutes, so
section
we'll
E,
see.
It ends with Elite.
I'm going to speed them up
Elisa,
just
and then on the next
a
page, all it has is Summers.
Goach.
So we're just going to reformat that. But as to the content, is there any issues or objections or questions, Mr. Summers?
I do have a question or an objection, both. I was not aware that there would be these types of other options for the jury. So I'm not very prepared to argue or include these in any kind of closing argument. I don't know if that's a valid objection, but I just want to state for the record that I'm a little bit surprised by
What happened here?
these lesser offenses, and I believe that it diminishes
Hey,
my ability
Max.
to.
I understand. I hear you. But I'm going to say that this is perhaps one of the disadvantages of representing yourself as you've chosen. The law includes category 1 lesser included that are required to be given to the jury. These are actually category 1, and the jury must be instructed on them and have the option of finding you guilty of something lesser than the crime that is charged. And then these are all of the category 1 lesser included instructions. So,
I understand. I thought this was an option for the state, not a requirement. That's the difference.
category 1s are required. Any issue, any difference, or comment from the state?
No, Judge.
And let me
Should have
clarify,
had
I-
all
I
you had all
verified
night,
that- well,
and you wanted
all
to
of
do
the ones you've
this.
included are in fact category 1 lesser.
So
Is
there
that
you
correct?
go.
Only category 1, Judge.
Okay. Now,
Let me
all right,
turn
so
it
I
up.
just want to verify. The law says category 1s must be instructed, even if the defense says I don't want them instructed. All right. So other than that question, sir, any objection regarding the content of 6.4 attempted second-degree murder?
No, Your Honor.
All right, thank you. Next, I have 3.3a, aggravation of attempted second-degree murder by carrying, displaying, using, threatening to use, or attempting to use a weapon. And this is as to, I apologize, this is as to counts 1 and 2, Mr. Summers.
Yes, I understand it, Your Honor, and I'm just double checking it with the first.
I'm curious how this
So
jury
this
is
a
going to
duplicate on
find.
page 20.
I don't.
You know, Ali, if I were a judge and I was sitting there, I would be thinking to myself,
Same language.
now look, in order to get this
but this is
position
where they're
as a
being
judge,
informed
I
that
went to
this
law
aggravation
school. I went to
also
college. Then I went to law
applies to the
school.
lesser
Then I
of second degree, attempted, I'm sorry, second degree.
had to take the bar exam, right? And now here I sit as a
sit
judge.
here, I don't recall any consolidation.
You
I think on this one,
have decided to
is
waltz into
perhaps
this
redundant,
courtroom
but
wholly unprepared as you have
I
no
don't recall ever
legal
consolidating it.
experience
It-
other
it-
than
it-
being
it's
on
gonna
the
get
other
pretty
side of the
confusing.
law
I'm
as a
concerned
criminal,
if
allegedly.
we do anything else.
And yet you think
Trust
that
me,
you
I'm
can
no
just
happier
come
than
in
anyone
here
having to
and
read
do
all
all
this
the
stuff twice or
do
all
all the
60 pages.
things, and I'm having
But
to slow
other
this
than
whole
state, did
system
you have any
down
comment?
Not as to that, Judge,
because
we do need to
you
revisit
decided you
3.4.
hi
We haven't
nosy
done that
Nana
conversation.
because you
Which was the
decided
previous one?
you wanted to represent
3.4
yourself
is the lesser crimes included. It needs to say the lesser crime
after
included is
you've
attempted
already dilly
second-degree
dallied
murder.
and postponed this trial as much as you
With a
could
weapon?
have.
I'm sorry, Judge, that's
But-
incorrect. Can you just get-
On the other
And
side
let me
of
just
that
give me a moment,
coin,
and so we can all turn back to it.
what I appreciate about this judge is that he
What
is
page are
being
we referring
patient
to?
My papers are-
with Mr. Summers in this endeavor
This is why we do these
because
so we can determine
he
any
is cognizant
issues before I
of
read it. It's actually on page 29,
potential
Mr. Summers. It's
problems
3.4 lesser included crime
arising
and I apologize
during
to
an
Chelsea, tell me
appeal
specifically what
and
page you-
thus a
So, Judge, I
whole
guess I'm
ass
questioning-
retrial.
The charge for count
Which
22
is-
is attempted murder in the first degree with a weapon. So do we need to list a lesser is attempted first degree murder, period, with no weapon? But I had the special finding on the verdict form where they would make a finding as to he's guilty of attempted degree murder, and then they make the special finding. But I don't know if we need to list that attempted murder in the first degree without a weapon is considered a
What's
lesser.
standard? What have you done before? I mean, what do we usually do?
Well, in another case, Miss O'Connor did the attempted murder in the first degree without a weapon. She didn't put without a weapon, but just attempted first degree murder was considered a lesser.
Well, I'm concerned also that the lesser crimes indicated in the definition of attempted first degree murder should then say attempted first degree murder with a weapon, because it wouldn't sound right if that didn't include weapon and the second one it also didn't include weapon. There has to be some distinction.
Correct. So we would need to fix that.
I agree,
So
Your
that
Honor.
would
There
add
needs to be a
an
distinction.
additional-
Jury
and let me-
instructions
I
are
mean, there's a chart.
difficult.
I don't have it in front of me, but
So it doesn't have for attempted first degree murder. It doesn't verify. There's not one for with a weapon and without. It's just attempted first degree murder, and then you have the aggravation for with a weapon. So there's not a chart for attempted first degree murder with a weapon.
Yes,
It's just
Allie.
attempted first degree murder.
So
Absolutely,
we can't
yeah.
say it's a category 1 lesser if it's not on the chart as a category 1.
It's right. It's not a category 1 lesser.
Yeah, I
'Cause-
mean, it makes
The weapon is a
sense.
special
You know, we
finding.
talked about like the appeals processes
I
lots
did
of
not include it,
times,
but
and
I know you've had other cases where you
usually
have included it.
the way an appeals process would go
Well,
is
what's
you
your request?
start
Your request
with
is not to include it because that was the proposed instruction. Mr.
Um,
Summers, do you want?
the trial errors.
This is one I think that it's
Right.
appropriate to allow Mr. Summers to weigh in on if it's not a category 1 because he didn't appear to want any
I'm
of the
curious
lessons. I told
if
him they're
this
category
fool's
ones,
going to try
and they
to
have
make
be
an
given.
appeal
But
on
this isn't a category 1.
an ineffective assistance
I
of
think it
counsel, given that
should
he's his
probably
own
ultimately be
counsel,
left up to him.
and he did it.
And the
This
state
trial,
didn't
this
originally
whole
request it, so
situation
I'm
is
assuming
problematic.
The state didn't want it. Mr. Summers, do you understand what we're discussing?
No,
Yes, whether or not to include the lesser with
Of
the,
simple attempted first degree, simple. That just the word doesn't even go with that. But of attempted first degree murder
that's not,
after attempted first degree murder with a weapon.
right. I believe it should not be there.
Okay. Do we need though anything about the weapon? I think I agree with Ms. Johnson that that's just an additional finding that the charge. Should it say? I want it to track though. Count 1 and 2.
oh boy.
I apologize. Jury instructions sometimes they're very tedious and
It's okay, Your
no
Honor.
offense to the Supreme Court, but complicated. But that's why I take time and want to make sure that they're absolutely
I appreciate you taking the time.
correct. So, does the state have a position on the lesser crime indicated in the definition of attempted first degree murder?
That
or
person
could it say
behind him, Allie, is
definition of
Mr.
attempted first-degree
Marchese.
murder with a weapon?
Initially, Mr. Marchese is a court-appointed attorney,
It's not in.
and at the start of jury selection, he was
an
lead
finding.
counsel.
I think it's.
And then when the victim
I mean, this is the
took the
opportunity.
stand
Yes.
on day 2 and was almost done testifying at the morning break, Mr. Summers here stood up and said that he wanted to, Mr. Marchese is the one that flagged that drew the attention of the judge and said that Mr. Summers had wanted to fire him as lead counsel and continue the remainder of the trial representing himself. And so the judge, after speaking to Mr. Summers, explaining to him what that meant, what that would entail, then agreed to allow Mr. Summers to finish the trial representing himself. And but initially he warned Mr. Summers he was not going to allow Mr. Marchese to be standby counsel, and that, he changed his mind apparently and allowed him to be standby counsel, although he has consulted with him a little bit, but not that much. He's pretty much done it on his own. And this is why we're where we're at this point. And now,
Okay. Yes, absolutely. Leave it as proposed
Correct.
and as requested by the defense. So, that's right. I'm at 3.4. Did we have something else?
Really, we left off on 3.3A, the second reading of 3.3A, which is after that.
Oh, so we were actually one part down. It's not after.
Well, but it should be, yeah, you're out of, so it's.
and I love how the clerk is just keeping this judge completely like
I'm
organized,
sorry
where
about
he,
that Lesser's.
Sometimes I don't think people understand how much
I think we agreed that we were
What
going
the
to do a
clerk-
second reading of 3.3A.
what the
That was
court
that was
clerk
my
really
ruling, and
does.
I'm going to stick to it. So, moving on from 3.3A is now 6.6 attempted manslaughter.
Oh
by
no,
act.
Allie, you're fine. We're
Mr.
just
Summers,
kicking it.
any
This is
issues,
cash.
objections? And this does
And,
have one of those italicized.
I only did
and
one
in
stream, babe. I
parentheses,
only
the
did it last
explanation of
night.
Justifiable attempted homicide and excusable attempted homicide are in instruction 6.1. introduction to attempted homicide, which was previously given. You see that
Yes, sir.
note on there? So that we're not doing it twice.
Understood.
So do you want me to italicize that?
Because I had intended to go live
No,
Wednesday
that needs
night,
to stay.
and then I
Um,
was in another
Oh,
live, and I wanted to be supportive, so I ended up pushing it
Mr.
back
Summers, do you have any problem with just eliminating what's
to
in the parentheses because
to
that's
last
preceded
night,
by
so I only
as I
did the
have
one.
previously instructed you?
No problem.
State, why was the italicized and in parentheses language here? Were you requesting it?
Judge, it's included. The italicized part is on the standard instruction, so I'm not sure if this is a situation where because it's italicized, taking it out versus the Supreme Court putting it in there to then allow your honor to simply read that saying this is where refer to 6.1 for that definition. I think
My recollection, I mean, I could be wrong, trust me, I'm not always right, but is that it ends in the past, that it ended there, as I have previously instructed you, period. This language I haven't seen before, but I'm not questioning you on that it's included in the standard. Do you have the standards up? Yeah, let me take a look at the standard to see if it has.
Yeah, just take a look at the standard.
You don't read it.
I think that's just in the standard letting you know.
right.
And the interesting thing
So
about
are you
this,
requesting-
Refers back to
Case
the instruction
also-
of 6.1. So
ma'am,
it's fine if you
don't
want
talk
to take out
over
with
me.
the
That's
italicized
very
in the front.
rude.
But I guess what I'm trying to figure out is why it's in the proposed.
The other
instruction. Were you
interesting
requesting-
like
did I
component
read
to
what's
this
in the
case is
parentheses
that how all
or
of this
not
started
requesting?
out.
Judge, I left it in
Is
there because I wanted the court to know that that was in
the
standard
victim in this
instruction, so
situation,
we
the
need to make sure we
ex-wife,
address it. However you want to
she's an
address it,
ex-wife
is
now.
fine,
At
but
the
I wanted to make
time,
sure that
she
we
was
protect
seeking a
All right, well, the
divorce.
proposal is that we take it out, and I
And
think that Mr. Summers is in
Mr.
agreement.
Summers
Correct?
over here had
All right, so I'm taking
already
it out.
been
Next, I have
convicted on
3.3a,
a
aggravation of attempted
federal
manslaughter by act,
fraud
preparing, displaying,
charge
using,
out
threatening
of
to use, or attempting to use weapon. This is
Pennsylvania,
lesser
I
as
think
to
it
counts
was,
1 and 2.
and was awaiting sentencing on that
Issues,
conviction
questions,
when
objections,
he
Mr.
kidnapped
Summers?
his wife, allegedly,
Next,
according to
I
the
have
charges.
5.1, attempt to commit
And
aggravated battery, lesser as to count 1.
so
And why isn't it as to count 2? State?
that's interesting because I feel like he's just honestly, I think he's monkeying around in this case because it puts off and defers the sentencing on the other federal case. Because
Also,
even
taking a
though
look at the
it's a
first two
federal
sentences,
case,
it's kind of redundant. Is
obviously
there a
these
way that we can
charges are
change that or
higher.
address that?
You know what I mean? In severity, in seriousness. And so the federal government
See
was
how
like,
it's-
we'll
I
wait.
can't imagine that
right?
both of those
But
are
now
required.
he's just putting it off and putting it off and putting it off.
We have to pull it. I need to pull up the original.
He's just been
instruction.
monkeying around this whole
So attempted
time,
aggravated battery is a category
trying
one
to
lesser.
prolong this. Oh, we're all in this same boat, you guys. I only had one
It says
stream,
the
like
same
I
thing in
said
those two
prior to
sentences,
this one.
actually,
I wasn't really
ever
on the
so slightly
ball
different. I don't care
with
which
the.
one you
I watched it
The
and was
top
kind
one,
of
Judge,
keeping an
not the
eye on it.
All right, Mr.
I
Summers,
should have
do you see
streamed
how
it.
Those first two proposed sentences are practically identical, but it's just repeated twice.
I do.
Do you have any problem with removing the second one?
No.
All right.
Mostly because I'm waiting
5.1,
for
standard instruction for attempt to commit crime. That first paragraph
the
it says to use when attempt is charged or is a lesser included offense. So that is the more
trial of George Warren the
top.
Yes.
Okay. not a
fourth.
problem. I accept that. But why is this
Not
only
Warren.
a lesser as to count 1 and not a lesser as to count 2? Was the only question I had.
Is that Warner? And George
It
Warner
needs to
the
be a
fourth
judge.
from out of Ohio in the Pike
All right. We'll make
County
those changes. Mr.
family
Summers, do you disagree?
massacre.
Okay, we have
Because
the same
that
thing in the second
trial
paragraph. The
is
crime of
set
aggravated battery
to
is defined
start
as, and then to prove the
August
crime of aggravated battery, the state must prove the
29th.
following 2
And
elements.
Wagner,
One
thank
of
you,
those has to come
Amelia.
out, which is in
Wagner,
the
my
standard.
goodness. Jen Lou,
Which
get
one is
it together,
pursuant
sis.
to the standards more appropriate?
Wagner,
Ms. O'Connor?
Charles Wagner the fourth.
I'm sorry, Judge, where are you at?
Under element 2.
And I'm
it says
I
the crime
haven't
of
seen
aggravated
anything
battery is
like
defined as,
official
and under that it says to provide
about
to
whether
prove
it's
the
going to
crime
be
of
streamed or
aggravated battery,
not.
the state must prove the following
But,
2 elements beyond a reasonable doubt. The first element is a definition of battery.
Given the fact that
I think the second one is more appropriate. I think that first one is just
all
hanging
of
there
the
is-
proceedings
know why it's
have
there.
been like the motions,
Because
the
that was probably
filings,
the beginning
pre-trial,
of the
also
actual aggravated battery
other
instruction.
defendants
So is that a typo?
have
So in the
their
standards for
plea they've
5.1,
pled guilty
it
some
says
to
the
some
crime of,
charges.
and then
Those
put
have been
crime
streamed.
attempted is
So I'm
defined
really
as
hoping,
in
and I have
elements
I'm
of the crime
optimistic
attempted.
that his
So,
trial will be streamed, especially given the fact that
Does it make sense to have both?
No.
I
don't.
his
think
brother
that-
Either works.
is
The second
going to testify
A little longer
in this
and
case.
it has the explanation.
And
The first
in-
element is the definition of battery. I
the
will tell you that my preference is for that one. Any objection from the
I'm
state?
going to
We
turn
defer
this
to the
down. I
Any
feel like I'm
objection, Mr.
screaming.
Summers?
No, Your Honor, whatever you.
I'm scratching
The,
aggravated battery is defined as
Jake's
colon.
testimony. Okay, so
Anything else that
the death
so
penalty
we're onto the second
for
page.
Mr.
So
Wagner
make sure that we're
is
all
on
the
the
same page
table.
as to
and the
reviewing
only way
5.1
that the
technically
death
aggravated
penalty
battery
would be
and other issues.
removed
Questions?
is
Objections?
if
I believe it's
Jake
the first element is a
Wagner
definition of battery
testifies
defined as.
to the what is this?
That's not
I
the
want to
way
get
the
this
standard language is. I'm
correct.
gonna follow the
This
standard
language
You may have an issue with the Supreme Court and think that it could be done better.
to the state's
I think that's the same thing. I'm
satisfaction.
not going to say that, but I'm going to follow the standard.
So
That is-
if
Okay.
the state
Any other questions, issues?
doesn't
or,
feel that
objections
Jake
as to
Wagner
5.1?
testifies to
All right,
their
next I have
satisfaction, they will not remove the death
5.1
penalty.
attempt to commit
All
battery.
and that okay, so that's an important
And
element
it
to
says
that
it's a lesser
to that
as to
case
count two.
because
Is there any reason why it's not a lesser or should not be a lesser? as
their
to count one?
father is up is
No,
scheduled for
the
trial
instruction
after
just
all
now
of
needs to say
this
lesser
and
to count
the
1 and 2.
and Jake
We
Wagner
made it.
has agreed to
This one
testify
will take
So
a
now
while.
we're at
for the
5.1,
state
attempt to commit
so that
battery.
the
That's very
state would
different.
remove
Lesser.
the death
And it always
penalty
says count two,
from
but it
his
should say
dad
count one
and
two.
his
The other one says
brother.
only one and should have said one
And
two.
so I
This one
do
says only
think
two, but should
that-
be, I think, one and two. I'll give you
I
one.
think the judge, given the fact that the judge has allowed court cameras in the
Reason behind this,
courtrooms,
Okay,
but I
well,
cannot remember at the
courtroom
moment. It was a conversation
for
I
all
had
the
with Mr.
pretrial
President.
motions
I can't
plus
remember right now.
If you
the
need
other
it.
defendants
I think
have
the way we
um,
discussed it is appropriate.
pled guilty
One and
to
two.
other
Okay, Mr. Summers.
their
any
to their
disagreement,
respective
questions, or
charges. I
objections?
really am
And I do
really
too.
optimistic that they are going to let this be covered.
In the body of
And
it says the crime
speaking
battery
of
is defined
other,
as colon, but under that it says
upcoming
through the crime of
trials,
battery.
you
I'm
know
striking the crime of
that
battery is defined
the
as
Vallow
colon.
Daybell
Any
trial
objection, comments,
is
or questions from either
scheduled
side?
for January
I agree
of
with that.
2023, which seems like forever away. But think about it, you guys. We're pretty much, for all intents and purposes,
Which one did we
at the
do?
end of August. We're
The top one.
really about to be
Thank you, Mr.
September,
Summers. I'm
right?
scratching
So
the
that
word
only
prove to the
gives
defendant,
September, October,
attempted
November,
to
December,
commit
4
and
months, and then
simply
boom,
moving to
it's
prove the crime of
January,
attempted
right?
battery. The state
This year has
must prove
gone
the
by
following two
really
elements.
quick.
Go right into the
And
element instead of the,
Alex
subject.
Erickson and I are going
Any objection,
to
state?
be covering
Next, I
that
have
trial
3.2,
together.
false imprisonment,
So we're
lesser as
gonna
to count three.
alternate whose
Mr.
channel
Summers?
we're on and stuff like that. And she and I are
Questions, comments?
working on getting
Questions? Thank you.
working out what we're gonna do and all that so we can present it to you guys.
Mine is what you gave me, so
Because I know a lot
I
of
can say it
people,
needs to-
including myself,
the definition
obviously,
of secrecy,
are
it needs to
really
say Mrs.
are
Summers,
are
Mrs.
have been
Young.
anxiously awaiting that trial. We want justice, and so we
Mr.
want to see justice
Mr.
done.
Summers, any objections
So
to
that's
changing what is down
coming
in
up
parentheses,
as
alleged
well.
Victim to the actual name of the alleged victim, Elisa Summers.
No, I understand.
And I have no idea
That change
because I
you
haven't
made it?
looked. I'll look again to see because I haven't seen
Next, I have
anything
8.3 battery, lesser as to
about
counts
how
4 and
long
5.
George Wagner the Fourth's trial is expected to last. I mean, this was this
I
is the
see Summers
single
in it.
most
It's in there
expensive
twice.
Oh, okay, it's in there 3 times. It's twice it has Summers, but 1 time it has
investigation
Elisa.
and
Mr. Summers, when you see
prosecution
that, it's actually
in
in the
Ohio's
element 1
history,
towards the end of that first sentence
apparently.
where it says touched or struck. It just says Elisa. We're
It
gonna
took a
add
long time to
Summers
get
as,
to
it
this
is the first
point.
time
I
and the last
mean,
time that her name is mentioned.
I understand.
you know,
Any
so
other issues, questions or objections related to 8.3?
No, Your Honor.
All right, and you made that change, you got it, Summers? Next, I have 8.9.
and it's also a
culpable
fairly
negligence, lesser as to
complicated,
count 6.
simple and complicated all at the same time, you know. So, but
I'd say to add all the additional-
so I have no idea how
No,
long
no,
it's
no, no, no,
expected
but
to
you wanna make
Make the change
last.
on this one?
You know, usually when I have
Leave as is.
aw,
Mr. Summers, any questions,
congratulations, Chick
objections,
Tracy.
comments? It's going to repeat now 3 times.
I understand. No.
All right.
Usually when I say, oh, I think this
next
is
I
going to be
have
a long
8.9,
trial, it's over in like
culpable
3.
negligence,
Look at
lesser as to
Anthony
count
Tote.
7.
I thought
Same
that was
language
going to be a
except
longer
the
trial,
first one was
and it took me
AS,
longer to
second
make
one
the
is LS. Anything, Mr.
opening
Summers?
video, which is
Next
why
is
now I've stopped
8.9,
doing that.
lesser as to count
I
8,
learned.
And the initials are
Um,
PS, which is correct, right?
than the actual trial
Next, I have
lasted.
count, just
So who
for
knows
record,
how
Mr.
long it's
Summers,
gonna
no
be.
objections? Next, I
There's
thank
the
you.
spacing on lessers to count 8 just needs to be fixed.
Also, the thing that I'm fascinated by
You're fixing it?
about the Vallow
We did say we'll
Daybell
move forward,
trial
and you will
is
see
the
that real
fact
quick,
that
so you can
they're
see it.
being tried
Um,
together.
What I'm most concerned
And
about is
it's
the content.
I
and then
haven't
we will reformat,
that
send it to you,
that
and if you
doesn't
have
mean
any
this hasn't
objections,
hasn't
I
happened.
will ask you
Obviously, it's
once we
happened
give the
before,
final
but
copy,
I have
after
not seen a
reformatting
trial
if it creates any issues that you wish to raise.
with
Next, I have 3.9
co-defendants
culpable negligence as to count 9, and the initials are TS.
since
The only difference in this
that
one.
I can think of off the top of my head that I've personally like watched
All right,
since the West Memphis 3 when they
next I
tried
have
Jason
3.7,
Baldwin and
plea of
Damian
not
Eccles
guilty,
together.
reasonable doubt
I know it
burden
happens
of proof. Mr.
frequently,
Summers, you have an
but
opportunity to review
I'm
that.
not
Yes, I have.
watched one
Any
like that, and
questions,
so I'm
objections
very
related to that?
interested in that
No, Your Honor.
because
All right.
you've got
Next, I have 3.9, weighing the evidence. Now, this one is going to require
two
us perhaps
defendants
to take a look. There's 9 individual enumerated
and their
paragraphs.
lawyers, and I feel like there's going to be a lot of
Usually always
you
come
know
in. They're not always
legal
appropriate.
arguments made back and forth, which
So
is
take a
something
look
that I
and see if
always
any
enjoy
1 through 9
watching. I
is
love a
in this
legal wrangling. This is kind of
Starting at 6, Judge. 1 through 5 are standard.
this case we're watching right now.
State's
This
position is 6, 7, and 9 are not appropriate.
Not appropriate?
6, 7,
man
9.
is
All right, Mr.
not
Summers, I
prepared
need you to look at
to
6, 7, and
really
9,
make compelling and good
I
legal
agree,
arguments. So
disagree.
it's
The
you know,
proposal is to take out 6, 7, and 9.
I would leave 7, Your Honor.
but
And any pressure or threat used in
at this point,
testimony.
now I'm invested in this
You
trial,
agree,
and
Mr.
I
Summers,
want to
for
see
limiting
how
7?
this is all going to end out. What
Not
else? What
7.
all is going to end?
keep
How
7.
it's going to end up? I can't even talk.
I believe preferred treatment would
And
also
I appreciate you
would-
guys
I would
chilling
leave
with me because I really can't bring a whole lot to this argue. This is kind of the boring part of it, but it's an important part,
What, if any,
the
evidence do you
jury
propose
instructions so that the jury understands what the charges are, right?
I
What they
believe just
mean,
the number of
and they can apply what the evidence that was presented in court, go back and look at their notes. And this is important because obviously
Okay. All right. So
you're
6, 7, 9.
deciding,
You want 7.
Yes.
you know,
Well,
you're
Your Honor,
making a determination that will impact another human being's rest of their life. And you want to make sure it's done correctly. It's just very, very tedious.
I don't know. I'm not answering
And
questions. Is that your position?
it would make it better if there was another attorney,
Some argument as to
obviously, to
that.
make the argument for these objections that he's raising. That would be a little bit more interesting and perhaps more moving, but we
The
have to
credibility
deal
of
with what we have
some
to deal
witnesses
with. And
were affected
I'm just
by
trying to make it as
presence
interesting as I can with
media.
my commentary. And
The
I
instruction that I
feel
gave
that I might not be
simply
doing that great of a
is
job of it.
wrong
I
and
can't,
not
I mean,
led
I'm
by
not a
the
miracle worker. I can
court
only
in
make
any way.
things, so I can only do so
I would be
much.
arguing that closing.
All right, then so we're going to eliminate 6. 7, though.
And I've sped this
State
up. We
suggests
should
that
be
you
getting
eliminate, and you would
close
like to keep it. Is that
now.
correct?
Yes.
And I'm going to keep it. 8. State did not request to take that out. 8 appears to be appropriate. There were some on both sides, and there were references to prior inconsistent statements. I just want to verify. State, you're not asking 8 to come out, correct?
I'm really
Summers, you're
excited
not asking
to
8 come out.
collab with
8 remains. It becomes
Alex Erickson. I think she
7.
is
Now, number 9.
an incredible creator.
I don't believe there was any
I
evidence
am
of that.
very proud
Mr.
to
Summers did not testify. So, State, you're suggesting
call
nine comes
her
out,
a
just
fellow
because
true
you
crime
agree that
creator.
9 comes out.
I think she's a really great person,
Yeah.
just generally speaking, and I do like her true crime content. And I'm really excited to be
Mr. Summers, you're good.
collaborating.
Moving on from 3.9.
Oh boy.
Oh, yeah,
Can
you're
we
absolutely right.
speed
I forgot
this
there were
up
second
just
two
a little
pages
bit
on
more,
the-
Your Honor?
we
This
probably
is like
proposed to lower
it's
them.
like
No,
watching
all right.
paint dry.
We got to take a paragraph out that says that he became a witness. It's on the second page. Mr. Summers, do you see? It's 2 lines about the middle of that those paragraphs. It says the defendant in this case has become a witness. You should apply the same rules to consideration of his testimony that you applied to the testimony of other witnesses. We're going to scratch that. Do you agree, Mr. Summers?
I do.
All right. As to everything else, though, Mr. Summers, are you in agreement?
Yes, sir.
State, no other changes proposed? Next is 3.9A, defendant not testifying, which is absolutely appropriate under the circumstances. Mr. Summers, take a look at it. Let me know if you have any objections, questions, or comments.
No objection. No question.
All right. Thank you. Next, I have 3.9, defendant's statements. There were statements that were introduced into evidence. So, Mr. Summers, any questions?
Oh,
comments,
you're
or
welcome.
objections?
Thank you, Chick Tracy. I try.
No, Your Honor.
All right.
Well,
Next, I
thank
have
you in 5, 6, 7,
3.9C,
8.
eyewitness identification with specifically enumerated 1 through 9. Mr. Summers, any objection?
No.
Next, thank you. Next, I have 3.10, rules for deliberation with enumerated paragraphs 1 through 7. Mr. Summers?
Hello.
Next, thank you. Next, I have 3.11, cautionary instruction.
Now we're
Anything,
moving
Mr.
through it.
Summers?
No.
Thank you. Next, I have 3.12, verdict. We're going to talk about the verdict in just a second, but first, as to the content of this instruction 3.12, anything, Mr. Summers?
No, Your Honor.
All right, thank you. Now we're going to look at the verdict form, and there may be some changes based on some things that we've decided. I don't know that to be a fact, but we're going to go through each and every page of the verdict form to make sure that it is correct and appropriate. So, starting on page 1, the jury will find as to count 1, and then there are instructions, and there are choices A, B, C, D, E, and F. B, C, D, and E include the lessers that we've previously discussed. I don't think we made any changes related to those. Mr. Summers, any issues regarding count 1?
Your Honor,
Oh God, here we go.
is it appropriate? Is this a standard format?
It should be. It appears to be. There is a standard verdict form in the instructions. What is your issue or question?
At the end of A1 and B1 and C1, it says attempt to use a weapon instead of the alleged weapon.
No.
Is that ambiguous? No.
It's not standard language. This is standard language on those specific things.
Then no question with count 1.
Okay. As to count 2,
Judge, the only thing that I think we need to take out as charged on the A part, because he's charged with attempted first-degree murder with a weapon.
it's the finding that
Makes it.
I know.
So I agree with it. It's just scratch as charged, and then all the rest would be lessers.
Mr. Summers, any objection?
No, I understand.
All right, I'm scratching as charged. As to count 2, there are choices A, B, C, D, E, and F again.
And I think we need to
Take out as charged. Mr. Summers, agree?
Yes.
Taking that out, any issues, Mr. Summers?
No.
After that, as to count 3, there are choices A, B, and C. B is the lesser,
Understood.
and as charged remains. It's appropriate in this one because there's no special findings under A. Next, I have count 4 with choices A, B, or C, with B being the lesser. Mr. Summers?
No issues.
All right, thank you. Next page, page 3 of the verdict form, starts off with count 5 with 3 choices, A, B, and C, B being the lesser of battery.
Judge, we need to go back to count 4 and 5. We need to do the special finding for the penetration.
Oh my
You can send that
goodness.
language. Yes, we'll send a language.
Well, we probably have it in the standard. I imagine that it's in the standard.
It's not. It's the special finding language, Judge. I can.
She can just email it. That's
All right. Well, I just want to make sure that I read it and Mr. Summers is aware of it and is given the opportunity to comment.
We can pull it up and read it now, Judge, and then we can send it.
All right. Read the language that you're proposing be included in counts 4 and 5. This is a special finding under count A. Mr. Summers, what that means is just like in counts 1 and 2, there's that question where the jury finds yes or no. This is going to be a question, an interrogatory type form of question for the jury to find if they select count A, guilty of sexual battery by a person 18 or older upon a victim 18 or older as charged. There will then be a question for them to answer. And that question, the language of that question is?
Judge, it would be, did the defendant's penis penetrate the vagina of Elisa Summers? Yes or no?
You understand that, Mr. Summers?
I understand that. Is that an enhancement to the charge?
It's for the score sheet to get the penetration points.
It can't affect your sentence, so that's why the jury has to find it.
And do we also need another instruction within the first part of the packet with the charges?
It includes penetration or union.
It has that definition. That's one of the findings in the
He doesn't understand this part, of course.
elements, I believe, correct?
Yes, Judge, in the elements.
Can you read the language one more time? The question?
Did the defendant's penis penetrate the vagina of Elisa Summers? Yes or no? Just, it's almost, the finding is similar to the findings of the aggravation for the weapon.
No, I understand. Any other questions, Mr. Summers? I do believe it's appropriate and required.
No, it's just in 11.4, it says sexual organ of Trevor Summers, not penis, but I don't know if that matters.
State, what's your response? I prefer to be as consistent.
I would agree, Judge. Let me fix
Yes, I would also agree. Be completely consistent. Mm-hmm.
That's fine. So we would say, did the sexual organ,
So in the question, interrogatory, instead of penis, we'll say organ
sexual organ?
to be consistent with the instruction.
Correct.
Mr. Summers, you all right with that?
Yes, I'm fine with that.
Okay.
I still am wondering if we need an additional instruction in after 11.4 for that enhancement or not. Or I'd like an understanding of why we wouldn't need that, just like we have the additional enhancement under.
It's not an enhancement. it's
Well,
not an
if he's making a response, I'll give you an opportunity to respond to his response. So he's making a request, and I'll give you an opportunity to respond. So that's your request,
Yes, I'm.
that we include information in the instruction regarding this question.
Yes, the same way that there's instruction for the with a weapon, this would be with a sexual organ.
Well, I suspect their response is going to be that one is an enhancement. This is for purposes of a finding that is on the sentencing guidelines. Say, what's your response?
That's correct, Judge. So the aggravator for the weapon takes the level of the offense up a level and a degree. This does not change the level of the offense or the degree of the offense. It simply is for us to be able to get the penetration points on the score sheet.
Which ultimately could affect the sentence, and thus is required that the jury make a specific finding.
Correct.
All right.
Understand?
Okay.
Thank you.
You're welcome. What count were we on?
5.
5? Oh, I'm sorry. Yes, 5. So now 5, choices A, B, and C. Any,
special finding under A.
right, because this is the same sex bat. So the same change under A as to count 4. Count 6, choices A, B, and C. And this is going to be the same on 6, 7, 8, and 9. So, Mr. Summers, I'll let you take a look at, and then if you have any comments, questions, or objections as to the language on the verdict form regarding count 6, 7, 8, and 9.
No, Your Honor.
All right. I do have a formatting issue.
I don't get attached to formatting.
Okay. So just so you know, and when you get the final version, it's not going to look the same. You can take a look at, but the way it leaves the hanging from the page 3 to 4 is not going to be that way. There will be no hanging. We, the jury, as to count 10, choices A and B, there's no lessers. Mr. Summers?
Understood. Thank you.
You're welcome. As to count 11, choices A and B, no lessers.
Yes.
All right.
Understood.
All right, that's the verdict form. So
Good.
with those changes that we discussed and agreed upon, is there any objection, Mr. Summers, to the form of the verdict?
No, Your Honor.
Next, thank you. Next, I have 3.13, submitting case to jury. Questions, comments, or objections?
No, Your Honor, I believe you read this to the jury already, correct? You would need to read it again.
No, I don't think so. This is, I shouldn't have. 3.13, submitting case to jury. I mean, there may be some similar language that was in one of the introductory, but it wasn't.
Yes, there's some similar language. I understand it. No question.
No objection?
No.
All right. That's the last instruction that will be given to them before I send 6 of them back to deliberate. I will let them know and ask. Looking for my chart. Do you have an extra chart for me? I'm sure mine's up here somewhere, but. So we're all on the same page. I will be letting number 7, Anthony Tadone, And number 8, Dawson Lefevers know that they are alternates and they will remain behind, and I'll send the rest of them back. I'll also let them know that the evidence, the instructions that I read, and the verdict form will be coming back to them momentarily. I will give you all an opportunity to take a look at any or all of that you wish to before the bailiffs take it back into the jury room. We also are going to need to have a clean computer back there if they want to listen to or view anything. Okay. And I'll request that you show that to Mr. Summers so that he can verify any of those things, including the evidence, the instructions, and the verdict form before it goes back.
Yes, so there's no DVD player back there.
Apparently there is, but it doesn't work,
Yeah.
Okay.
much like the equipment in the courtroom.
2.13, did we address that? That was included in the packet. I don't recall hearing that.
I don't know. What is it? Tell me what it said.
It's the prior inconsistent statement as impeachment.
Oh,
It would have come after 2.7 in the packet.
Okay, so
let me just find it.
it's
That was in the very beginning with
Yeah.
some like the
I
The Williams rule, the edited instruction, things like that. So
I don't
leave it up to
know.
the owner and the defendant if they
chick
want
tra-
to-
nonstop mom. It felt like
or it was never
forever.
used, so then it wouldn't
But
be
it was
included.
Right, I
probably-
thought that was an instruction that's read during the trial. If it comes up, we have the
I
instruction
believe that he only
talks about
used their
prior
last
inconsistent
name, so
statements in weighing the evidence.
that probably should have been muted. But
I apologize. I had it in front of me. Can you read it to me? It's up here somewhere.
The evidence that a witness may have made a prior statement that is inconsistent with his or her testimony in court should be considered only for the purpose of weighing the credibility of the witness's testimony and should not be considered as evidence or proof of the truth of the prior statement or for any other purpose. But I think you're right, Your Honor. I don't think it would have been read before this
Right,
would have happened, which it was not requested.
Right. Yeah, and I found it, and I found my chart, jury chart. So no, it's included in weighing the evidence. There is a specific enumerated that we went over, and we ultimately all agreed upon they will be instructed on weighing the evidence regarding prior inconsistent statements. All right, so the next step, I'll give you all a short break, but the next step is to bring them out, do the closing arguments. State, you have any idea approximately? Are you splitting? Who's doing closings?
We're splitting it, Judge.
Who's going first?
Miss O'Connor.
All right, approximately, I know that probably don't have a iPhone that you can put up in front of you and stick to necessarily what you tell me, but if you could give me a rough estimate.
uh-oh, what happened? Uh-oh. Hang on.
Of time, just so that I can pre-plan if I need to take a break, give the jury a break. How long do
30
you
minutes
believe
max.
total? I'm sorry.
30 minutes for me.
And Ms. Johnson, your rebuttal?
45.
Okay, so an hour and 15 total from the state. Don't have to use all of it, but estimated an hour and 15. Mr. Summers, any idea of how long you intend to argue to the jury?
About an hour.
Okay.
An
And,
hour?
Let me just tell you that that is not an opportunity for you to testify. You did not testify. It is absolutely an opportunity for you to argue your case, but your argument will be limited to any of the facts and testimony that was introduced during the course of the trial.
Understood.
You can't add new stuff. You understand
Yeah.
that?
Yes, and would you like me to address when I'm speaking of myself as me, myself, and I, or as Mr. Summers?
I do not care. I am not going to tell you. I do not have any preferences. It's entirely up to you. However you wish.
Okay, I just didn't want to be construed as testifying.
No, well, as long as you're not adding new evidence, and so if you're talking about stuff that was in evidence, including statements of yours that are in evidence, but whether you refer to yourself as Mr. Summers or I said, that's entirely up to you. Say, did you have a position on that? I mean,
No, Judge.
okay. All right, let's take, I suspect, I don't know how much of the 45 minutes, we took all the 45 minutes, I
You're
suspect.
way over.
I'm way over.
Stay at Tuxedo.
All right. Well,
Way over.
is it-
There you go,
You're
nonstop,
back?
Mom. Way over. 45 minutes is how long that took.
It took 2 hours with jury instructions?
Yes. No way.
Oh,
Yeah, it did.
All right. Okay. Well, I want
Yeah,
to give them
'cause
a,
I'm
a
at the
short
2
break,
hour mark.
and we'll print all that out. What I suspect, because the instructions are very long, okay, I suspect that if things go as planned, I will be giving them a break before I begin the reading of the instructions. I mean, they're going to have a break if each side's going to take, an hour, and the instructions are going to take a good part of an hour. We will plan on having them lunch at an appropriate time. It may be later in 12. We'll figure that out when we determine what time we're getting started. But I suspect the plan will be to have lunch ready for them when they go back after closings from both sides and instructions from me. I don't know exactly how long it's going to take. I'm often accused of reading too fast. So I will try, even though there's a lot of instructions, to be aware of that and not read too fast. But it's going to take a while to read. 60
Here's the
pages
thing.
of
Okay, now I
instructions.
need to know
So
what
that's
you
the
guys
plan.
want
The
to
plan
do.
is to give them a break at some point.
Hold on. I'm
It's
going to hear
most
what he has to
likely
say.
appropriate after the rebuttal argument and before the instructions. That seems to be the most logical time for a break. Unless either side goes longer, and then I don't want to keep them much more than 2 hours without having an opportunity to go to the restroom. I hate to do it, though, in the middle of your rebuttal. You see what I'm saying? If she takes 30, he takes an hour, we're an hour and 30. And if you take an hour, I just can't do that. I have to break in the middle of your rebuttal. It's like you all know the ground rules. I don't like to surprise anybody. Same with you. If you go longer, I don't have a big hook up here.
I don't know
I'm
what
gonna
we should.
pull anybody off, but
Never mind. I was
I
thinking,
will tell
okay.
them that
I was
each
going to
side
say,
has
I don't know what we
instructed
should
me
do here
that their
because,
closings
like, we just
are
sat here this whole
approximately
time
an hour.
out,
Is that all right,
and
Steve?
are
I know you
doing
said
the,
hour and 15,
we've
but I
listened
can
to the
say
jury
an hour to hour and
instructions.
15.
We know what they're going to be.
So that if either side
And so
goes
if he
2
was going to
hours,
do
they know that
the
you
jury,
told me
Your
that it
Honor,
was going to be
you're
an hour to
you're
hour and 15.
I don't want to talk over you, but dadgum.
Kind of keeps people
So
honest
here's,
on
I
their,
was thinking,
their
okay, well,
estimates.
if he's going to read the
So,
jury
I
instructions
just wanted to
first,
be all out there
and
so
then
that
it's
what,
going to be
break.
closing
The other thing I tell
arguments,
them, I've told them before, if they need to take a break,
like,
don't be surprised
maybe
if
I'll
the
just
deliberations are
end
ended.
the stream
They
and
need a
then
break, I'm
start
gonna
a
take
new
break.
one because we
All
have
right,
already
take,
just
take
sat
a
here
few
through the
moments.
jury
We'll come back and
instructions
do
already
this.
because they've hashed it out. So now we know what they're going to be. But evidently, that's not how it's going to go. So it's going to go where the closing arguments happen. There's a break, I guess. And then the rebuttal closing argument is going to happen. And then the jury instructions. So now we're having another, oh my goodness, let's see. I'm still a little teeny tiny, I think, bit behind. No, I'm caught completely up. Hold on, let me fix this. All right. Oh my gosh. Yeah, all the way caught up. So I guess we're going to have a break and then closing arguments. I think a 15-minute break, although this is what I'm confused about. Why is there a break right now? The jury has been in a hold pattern they started a little bit after 8:30. So they brought the jury in. He told them what was going on, dismissed them. It's been 2 hours now. They've had, like, what more of a break do they need? You know what I mean? They've just been in this hold pattern. So I guess they're taking it. I suppose it's not really a break. Basically what they're doing is printing out everything, the packets. So I think he said 15 minutes. And then we should be getting to the closing arguments. But, bruh, I appreciate you guys hanging in there with me. This is where yours truly sort of like, yes, all because of this. Yes. Because they had to take extra time for him to, for it to be explained to him. Whereas if an attorney was there, then the attorney could have just they didn't need the explanation, and then the argument, they would have just made whatever argument they were going to make, and the judge would make a decision, and then boom, that would be that. You know what I'm saying? Like, there would have been a little back and forth, and it would have this if there had been another attorney there instead of him representing himself. Yeah, it probably would have taken 45 minutes. But the Rudes, I can't. Like, I'm all for our justice system and making sure all the I's are dotted, the T's are crossed. I'm totally in support of that. But what I am not in support of is a person who has zero legal knowledge, like, at all. I mean, and that includes me. You think that I would ever get up, God forbid I'm ever on trial, knock on wood. But do you think that I would ever get up there and think that I could represent myself because I've watched and commented on some trials on YouTube? Absolutely not. And I guess that's why I'm impatient in this situation, because I'm just like, what in your mind makes you think that this is a good idea? Like, at all? Because let me tell you, spoiler alert, it was not a good idea. In fact, it was a very bad, wrong idea. And now we're all stuck. Waiting because of you and your wrong ideas. Exactly, Chick Tracy. We're all sitting here waiting around like we don't have anything better to do. I don't actually have anything better to do. I love hanging out with you guys. Well, no, it was definitely not a good idea to do all the things that he is accused of doing in this case. You're correct. That's a very astute and on point observation. Nonstop Mom, you are correct. He shouldn't have been doing any of the things that he was doing. And you know what I was just thinking about? So remember how he was saying the intent, right? There was no intent there. And the state was arguing back and forth. There was a letter written in the back of that SUV, and there was also, if I'm not mistaken, a video. And I cannot remember now whether or not it was the letter or the video where he is essentially telling his kids, their children, basically, we thought this was the best for all. You know what I'm saying? We did this for you, I suppose. It was like, So if there was no intent, why was there a video and a letter? Yeah. 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 I mean, they couldn't. I don't. Okay, I don't know how to answer. Well, I mean, I can't answer that question with 100% certainty, and the only reason I can't is maybe they did, but I can't imagine that they would. I know that when it was determined that Mr. Summers was going to be allowed to represent himself, that the state then streamlined their case. I do know that the letter was testified to by the victim. She spoke about the letter that he had, that that he was writing, but also no, it couldn't have been left out because in her direct examination, the state spoke about the phone and that there was a video on it. So I don't think they left any of that out. But I'm just curious as to, I suppose that if it had been an attorney objecting and trying to make the argument for lack of intent and abandonment simultaneous, which an attorney wouldn't do. But I suppose that maybe they didn't mention some of the things in their argument as to why he shouldn't obviously be acquitted because, and that's why they mentioned that's why they used the victim's testimony essentially. That makes sense. Okay, now I understand. I'm sure that they're going to talk about the letter and the videos. I think it was more than one on the phone in their closing. So I'm guessing we'll all have this pretty well like wrapped up, explained to us. That's why I kind of didn't go like at this point feel like okay, we should go back because that's what the closing argument is for. They're going to basically lay out the case again. You know what I mean? All right. So give me un momentito, por favor. I'm going to let the pupster out, but I will be in chat. I'm just not going to be talking on this talking. I'm just going to mute, but I'll be in the chat. Be right back.
very much. All right, I have my stat here. You should have been provided the stack of the changed instructions. You will have time, as I indicated before, I read them to the jury, so you'll have more time. But I do want to, now that it is 10 minutes to 11, go ahead and get started with closing arguments. So I'm going to bring them in. I suspect that they're all here. I'm turning to the instruction that I'm going to give them, which I believe is 2.7. Let me just.
Good night, Chick Tracy. Sweet dreams. Let's see. Hold on. Amelia, I can answer that. So it depends on who you have doing the delivery, but I will tell you that for Walmart, they any orders over, I think it's either $30 or $35, get a steep discount in the delivery charge. And Kroger, I don't know if you have a Kroger there. I've never done Instacart. I've only ever done Kroger, but I did look at like Walmart's options. Kroger, I don't know if you have one there, like I said, but they do it a little. Kroger's is different. So Kroger has their own like service. And when I ordered groceries online from Kroger, it was like a refrigerated truck, like a box truck, and it was with Kroger on the side and all that. And I have to say that that's Stevens Hangout at the Walmart. But I got everything that I ordered. It was all packaged. You know how like when you go grocery shopping and you're there, right? You line your you unload your cart the way that you want the groceries to be bagged, because you obviously don't want to have like food with like soap. You know what I'm saying?
For that, you not hold that against
So,
the parties at all.
Kroger does a really good job. Oh, that's right. It was at Kroger. He did hang at Kroger, not the Walmart. My bad.
And that's what took a while to. I needed to make sure that they were all appropriate and correct. So we
Tia, thank you for being here. You're coming back in the
I have one very brief
perfect amount of time
before the
because now they're
argument.
fixing to have
The
the
parties
closing
now will present
arguments.
their final arguments. Please remember that what the parties say is not evidence or your instruction on the law. However, do listen closely to their arguments.
Like I'm really picky when I unload my cart about how I put things together. Like I put all the cans together, right? All of the frozen stuff together. Then the meat is by itself, and then the refrigerated stuff, and yeah.
State ready to proceed.
And at the very
All right,
end
Ms.
is
O'Connor,
where I
you may
put
proceed.
like my cleaning supplies, paper towels, toilet paper, soap, stuff like that. All right. After 11 billion hours later, here we are at the closing
May it
arguments.
please the court, Mr. Summers, co-counsel, gentlemen of the jury, a nightmare that Elisa Mathewson has had to relive for 5 years now. To relive in front
Me
of
too,
you,
Tia.
testifying here during this trial. Relive the traumatic events that she was forced to endure by that man, the defendant. What this comes down to is a scorned lover. The defendant was not willing to come to grips with his divorce. with his ex-wife. If he couldn't have her, then no one could. And that is what leads us to what happened March 11th through March 13th of 2017. The judge is going to instruct you, and you will get a copy of these in regards to the charges. In order for the state to prove the crime of attempted murder in the first degree premeditated, the state has to prove to you these three elements. Trevor Stephen Summers did some act intended to cause the death of Alyssa Summers that went beyond just thinking or talking about it. Number two, Trevor Stephen Summers acted with a premeditated design to kill. And then number three, the act would have resulted in the death, except someone prevented him from killing her or he failed to do so. You're also going to receive an instruction for aggravation of the attempted first-degree murder with the use of a weapon. The facts are clear. You heard from Ms. Mathewson after the second act of sexual battery against her by the defendant, he makes her shower. He then has her get back onto the bed. He leaves the room.
Obvious trigger
gone
warning
for
here, you guys. Sorry.
some time. She
I'm
can't
always late
say
about these.
how much time, but he's gone for some amount of time. And then he comes back in and, quoting Miss Mathewson, all I saw was an expression of evil and hatred. And at that time, I thought, he's here to kill me. I'm going to die. And as she sees that look on his face, she notices he has something he is hiding behind his back. He then comes over to her as she is on the bed, tied up, and puts the pillow over her face. She starts struggling. So what does he do? He then gets on top of her, straddling her, applying more pressure to that pillow, to the point where she is thinking to herself, she knew where she was going. She was going to meet Jesus. And then she loses consciousness. And we know he did this because he admitted to that to Sergeant Remia in his post-Miranda statement.
At this time, Alice is laying quietly asleep
And we
on
know
the bed,
that he stopped,
behaving.
took the pillow off of her. Otherwise, we would be here for a different case. There was no heat of passion. One of the additional instructions as far as the attempted murder is that you will see that it is not a heat of passion. This is not a heat of passion. He knew exactly what he was going to do when he went into her room while she was tied to the bed. Keep in mind, this was hours after he had snuck into her house, shortly after 12:30 that morning. Hours after he had lingered in her home for several hours before waking her up in the middle of the night. After numerous times where he ties her up with rope, Christmas tree lights, a vacuum cord, there was no heat of passion. As to count 2, for the attempted murder, this was from March 13th, where they get to Little Harbor. He parks by a dumpster near the Hooks restaurant. We heard testimony from Ms. Mathewson that he is in the driver's seat. The defendant says that he needs to write a letter to his parents. So what does he do? He climbs into
Right,
the third
Tia?
row, gets directly behind her, who's in the second row. And keep in mind, at this time, she's tied up. She showed you. She's tied up with the rope around her body with her hands up in a clenched fist-like fashion up around her chin. If he really needed to write a letter to his parents, why go to the third row? Submit to you. We all know that that's not why he was going to the third row. He had already written all the letters. You had heard testimony from Ms. Mathewson that happened well before they were at Little Harbor. He went to that third row with the intent of pulling that rope and strangling her. State's Exhibit F5. We see the rope that was tied around Miss Mathewson's arm, that was used to tie around her body, and the rope that was then used to strangle her. Looking at State's Exhibit F6, this is a close-up of the rope tied to her arm. And then if you go back and look at the photographs that were taken by crime scene at her house, Ms. Mathewson's house, the rope that was found in the trash can, and this is in State's Exhibit Set 1, A38, we see the black rope in the trash can. The exact same rope. The rope that you heard Miss Mathewson say she saw him pull from his pants pockets the early morning of March 11th of 2017. He went to her house with this rope. Why would you go to your ex-wife's house with rope if all you're doing is intending to talk? State's Exhibit K3 shows you the linear line on Miss Mathewson's neck, on the left side of her neck, and K4 showing how that line goes around to the back side of her neck. And those are the photographs and observations that Ms. Hall, an advanced registered nurse practitioner who conducted the sexual assault exam, as you heard testify, observed on Ms. Mathewson. And you heard Ms. Hall say that these types of marks can take up to 24 hours to appear. So while you may see it on the left side at the time in which she did the exam, it's possible that there could still be some marks appearing on the right side of Miss Mathewson's neck based on the strangulation with the rope. You also heard the testimony from Ms. Hall that the linear line is consistent with that coming from a rope. And then what else did she say? That it had to have been applied with enough pressure to leave that mark. Again, this was no heat of passion. This was premeditated. He had no intention of them leaving that vehicle at Little Harbor. By the grace of God, what he thought to be an undercover vehicle drove by, and he got scared. He failed to follow through with what he intended to do for a second time. As to count 3, we have the kidnapping incident from the Walgreens. Go back, listen to that 911 call from Mr. Crosby, Exhibit C. Consistent with what he testified to here the other day.
I just want to give
We
you
heard
guys a
testimony
heads
that
up.
once they get
Hold
to
on.
the
Let me pause
Walgreens,
this just real quick so you guys can hear this. I'm down to cover the state's initial closing argument. I'm down to cover obviously his closing argument, but then I got other stuff I got to do today, and so I probably won't cover the rebuttal. We'll just maybe go over that this weekend.
the defendant parks the car away from the store. He goes into the store. Remember, her hands are tied behind her back. And she still had that blanket over
Yes,
her
Amelia,
shoulders
he
that
was.
put on before leaving the house. She's somehow able to move her arms a certain way to unbuckle herself and then open the door and get out and try and run. And she told you she ran to the main road because she knew she couldn't go in the store. That's where he was at. Hopefully thinking that somebody driving would help her. Unfortunately, the defendant saw her running out of the car and she wasn't fast enough. You heard Miss Mathewson testify that he grabbed her, picked her up, forced her back into the passenger seat as she is struggling and fighting to keep him from putting her back in there because she knew. She knew what was going to happen if he was able to get her back in that car. And then he drives off. You heard her testimony that she was able to get the door open one more time as they're driving. He stops.
Well, that's
the
a good
car,
question, nonstop, Mom.
then buckles her up, ties her, and slits her wrist, saying that's for trying to run away. The defendant admitted to Sergeant Remia that she ran. He went out after her, grabbed her, put her back in the car. He even admitted that her hands were still tied behind her back.
I think this is going to be an Anthony Tote situation, and I think we're going to get
And then he
we're
then
going to have
tied
a
her to the
verdict by the
seat.
end of the day.
He goes on to describe how from there, because now most likely the authorities are going to be contacted, that there's no way they're going to be able to go to his house and say goodbye to the children. So he drives for several days through Manatee County and Hillsborough County. In the kidnapping instruction, you will see For element number 3, the state has to prove the act was committed with the intent to commit or facilitate the commission of a grand theft of a motor vehicle. And that is in count number 10 as a separate charge. And the state submits to you that the grand theft motor vehicle started when they left the house before going to the Walgreens. Because we know her hands are tied behind her back. We know she's not the one driving her vehicle. We know the defendant is the one who took the keys, puts her in the back seat, and drives. We also know from his own statements, again, that he is the one who drove throughout Hillsborough County and Manatee County for the next few days, throughout the 11th, the 12th, and the 13th. At no point in time did Ms. Mathewson ever drive her own vehicle during those 2.5 days. One of the elements as far as the grand theft motor vehicle that you will see is that the defendant knowingly and unlawfully obtained or used or endeavored to obtain or use the motor vehicle. Well, we know he was using it. He didn't have permission to do so. And temporarily or permanently deprive. 2.5 days.
I don't think so. Coolest
She
reviews.
doesn't have access to her own vehicle. Several times throughout, she is tied either to the car, the captain's chair in the car, or tied herself. The state submits to you that the kidnapping facilitated the theft of her motor vehicle.
I also don't think that they're going to be
Now,
sequestered.
as to counts 4 and 5, the sexual battery, the state's required to prove to you 4 elements. And I submit that elements numbers 1, 3, and 4, those are not at issue here. We know that the defendant, per his own statement, had sex, according to him, with Miss Mathewson. And that his penis penetrated her vagina. We know that they're both over 18. The issue is element number 2, consent. So let's look at the definition of consent. It means intelligent, knowing, and voluntary consent, and does not include coerced submission. Consent does not mean the failure by the alleged victim to offer physical resistance to the offender. The state does not have to prove to you she tried to fight him off. The state does not have to prove to you that she said no. You broke into my home in the middle of the night when I was sleeping, attacked me, and tied me up. I call that rape. Miss Mathewson's words just the other day. That's exactly what it was. She felt that she had no other option. And I want you all to go back and pay close attention to the defendant's post-Miranda interview, because every other time the defendant talks about having sex, he describes it as sex. We had sex. We had sex. Pay close attention around the 15-minute mark when he describes the sex that occurred on March 11th of 2017. He says, and then we had sex 4 times, consensual. It wasn't forced, nothing, completely consensual. The one and only time that he described it as being consensual. Why is that? Counts 6 through 9 is the child neglect of the children. And I'm not going to put up all of the instructions because they are all the same. It'll just have the different initials for the children. But the state is required to prove to you 3 elements. That the defendant willfully or by culpable negligence failed or omitted to provide the child, in this case, this is going to be for Arden Summers, with the care, supervision, and services necessary to maintain Arden Summers' physical or mental health. He was a caregiver, and then at the time, Arden was under the age of 18. There's no disputing this at all. We know for a fact he let his 14-year-old daughter drive home, about a 26-minute drive, from Miss Mathewson's house to his house around 6 o'clock in the morning. You heard from Arden Summers, she didn't even know where she was going. Luckily, she knew how to use the navigation system in the van. And then once all the kids are home, there's no adult. You have Arden and her other siblings, Bryn, Grady, Landon, and Cooper, all home until about 3 a.m. on March 12th, when law enforcement knocks on the door of Carol and Stephen Summers, asking one of them to go over to the house because there's no adult. And prior to even Arden arriving back at the house with her siblings, we know that the defendant had left the youngest child, Cooper, who was 3, at home all alone because he was asleep. As to count 11, we have the violation of the DV injunction, the domestic violence injunction. Again, there is nothing in dispute with this count.
I know, right? Those kids, 14 years old, driving.
The
Like, driving is
interview, the
dangerous
defendant
under the best of
provides
circumstances, right? But she was not a
the
licensed driver. Bless it. And it's Florida.
video
Traffic is terrible here.
that the defendant made on Miss Mathewson's phone is Exhibit Y.
All manner of things could have gone wrong.
And we have the order of the injunction in service on him, which was Exhibit AA. So the evidence that you received in this trial is overwhelming. But all of it, the 911 call that was made by Mr. Crosby, the Walgreens video, the text messages that were between Arden, Landon, and the defendant, the videos the defendant made, the confession letter he wrote, the letter he wrote to his kids states Exhibit S3. Where he says We wish you the best in everything you do and will be watching you from heaven.
Sounds like intent to me.
His own statements to Sergeant Remia. The testimony from Deputy Cruz of Miss Mathewson when he was able to extract her from that vehicle, the sense of relief on her face, how frantic she was, how upset she was. Of course, the ordeal that she had went through, and the relief was because she knew if nobody had found her, she would be dead. I want to talk a little bit more about the defendant's post-Miranda statement to Sergeant Remia, as there are additional statements he made other than what I have already discussed with you. Contradictory to what the defendant claimed, this is not a situation where you have two individuals who are quarreling over a divorce. His comments to Sergeant Remia about how it messed up his mind, she was messing with his head, is nothing more than, again, him not wanting to accept the fact that their marriage was over. There were no mental issues or health issues that the defendant was having. This is not an insanity case. You will not get an instruction on that. And that is not something that you should consider. There is nothing wrong with him mentally. He just could not get over the fact that she began dating. And according to him, was lying about it. And that's what made him upset. Gentlemen of the jury, shortly after 12 a.m. on March 11th, 2017, when the defendant snuck into Miss Mathewson's house in a window on the side of the house, not through the front, on the side, he did not have the intention of just talking. You don't sneak into somebody's house in the middle of the night with the intention of just talking. I submit to you, he also never had any intention of either of them getting on a boat and going to the islands. His intentions were for her, at first, never to leave that house. And then when that didn't work out, to never leave that car at Little Harbor. The state has presented to you an abundant amount of evidence that proves beyond a reasonable doubt the charges in which he has been charged with.
Mr. Summers?
Thank you, Your Honor. Good afternoon, gentlemen. Good afternoon, Your Honor. Good morning, Your Honor. Good morning, gentlemen. Good morning, State. I'd like to just be able to share with you a re-representation of what we've heard over the last week. And I'd like to start with just helping you understand from the details that were given and consider that the condition of both myself and Mrs. Mathewson were not adequate enough to truly paint a picture that you could understand. If you recall, we spent a lot of time that weekend just talking, just trying to figure things out, wrestling around, fighting about a variety of issues. Some of them you heard about, some of them you haven't. But you do remember that we didn't sleep very much. Our emotions were all over the place. Our stress was high. You've heard these things through her testimony and through statements of others in this case. And so I ask you to please keep that in mind as you look through, as I walk you through the facts that were presented. I first ask you to pay attention to the photographs. As you walk through the photographs, I ask you to please look through them and notice things in the residence of Mrs. Mathewson. That there were no signs of a struggle. That there was not broken glass or dents in walls. There's not scratches on countertops or blood splatter. This was not a scene that depicted some kind of crime or some kind of anything more than what she described as wrestling around. And I also ask you to look and see that the things aren't thrown about as she described. Things are where they're supposed to be. You can see that we packed, we left, and we had a plan to go to my house. Her accusation is that she was tied to go to my house. But I ask you, does it make sense to go meet children with a woman tied up? I also
Does
ask
it
you
make
to
sense to
look
sneak
at,
into a home?
The items that were disturbed by law enforcement during their 3 times investigating that home. There are a number of things, statements that were made, including
Coolest.
a variety of articles within the home that weren't brought in front of you, so that you can't make conclusions, so that you can't corroborate the stories or the statements that were made here. I also ask you to look through the pictures of the vehicle. I ask you to consider that they don't line up with her stories either. Little things like the pancake platter sitting in the second row and not the third. Little things like a purse being full of all kinds of contents that were helpful to her, useful to her, that she didn't really need if the whole intent to take her somewhere and kidnap her or steal her car. Why would she need her purse? Why would she need her phone? Why would she need her charger? It doesn't make any sense.
Nothing
And I
about
also
what
ask
you
you
did that
to look
weekend
at
makes any
The
sense.
car handle. The car handle's far up in the front of the door. And her statement is her hands are tied behind her back. I think most of us understand that if you lean your back against the car door and you pull the handle, you're going to fall out. You're going to tumble on your head. But she didn't say that happened. I also ask you to look at the pictures of Mrs. Mathewson. You'll see the full pictures when she was evaluated and examined after these events. You'll see that the bruises line up with wrestling around. You'll also see marks, bruises on her arms where she said, I lifted her up through a ravine. And you'll see exactly that's true. We pulled her up through a ravine. You'll see that there are blisters on her heels. Again, I mentioned to you guys, or I questioned her about why she didn't put flip-flops on, or why she would put shoes back on if she already had marks on her heels. And her answer was non-responsive. And so,
Objection, Judge. Inappropriate misstatement of the facts.
Hold on. Well, I'll instruct the jury at this time that what Mr. Summers says during closing and the attorneys during their closing is not evidence in the case. I will instruct you to rely on your own recollection of what the testimony and evidence was.
gentlemen, if you remember, we walked through those fields for hours in muddy conditions. Those shoes, as Ms. Mathewson testified, were getting stuck in the mud, and clearly that's what caused the blisters on her heels. You won't see any kind of rope burns on her wrists or her ankles. They're not there. You also won't find any photographs of anything after that. The law enforcement failed to investigate anything further beyond Ms. Mathewson's condition to see if another bruise would show up on the other side of her neck, or if any bruises or marks would show up anywhere else. That would have probably been a normal thing to do. And you'll also see that we physically fought each other. I don't argue that with you. And I also ask you to look at the photos of Mr. Summers.
Wow.
Of myself. You'll see that I was in no condition to be interviewed by the police. You'll also see that if you were in that position, you would feel vulnerable. You'd feel taken advantage of. You see that I was restricted, I was captive, and possibly coerced. And I argued that. Aside from the pictures, gentlemen, I ask you to look at the videos. If you look at me at Miss Summers' house, I'm in a confused state of mind. We're going through a divorce. We don't know what's going on. I questioned Miss Mathewson about our conversations about her pregnancy, and she recalled some things that we had talked about. This was something that I want you to consider. I also want you to consider a very special moment in that video where I'm asking Miss Mathewson what else she would like me to say. I submit to you guys that when you're in these kind of positions, you can clearly see through the complexity of this evidence and through the variety of it, how the emotions are all over the place. I also ask you to look at the Walgreens videos. Mrs. Summers goes into, or Mr. Summers, myself, I go into the store, but that's the opposite of the state's witness. He doesn't see me go into the store. He doesn't even know where I came from. That's his testimony to you guys. He doesn't know what kind of clothes I'm wearing. He doesn't know what kind of clothes she's wearing. But this is the main witness that's supposed to identify that the one single thing that he saw was her hands behind her back. He said her hands were behind her back. I don't know how she ran out of the car, but were they tied? You have to make this decision. Again, I point to you, how do you get out of a car, your hands tied behind your back, and open a door and not fall out? I also ask you to look at that Walgreens video and see that it was parked right in front of the store. If someone's held captive in the car, I don't think it's logical that you would park right in front of the store. I think you would park somewhere where no one else might see that. I think you would probably park in a different way so that if you needed to, you could get out quickly. But the testimony was that the vehicle was pulled directly in front of the store, head first into the parking spot. I also ask you to consider looking at the vehicle not speeding away. No rush to leave there. It wasn't that much of a
Hold
concern.
on.
It was a moment of panic.
I'm going to stop you right there, as it is widely known that when you are committing a crime, the best, you only want to commit one crime at a time, right? So if you have a hostage in your car, the last thing you would want to do would be to invite the cops into your situation by speeding away. So that is a poor argument at best, but please continue.
As you also look at the other videos, please look at the McDonald's video. Mrs. Mathewson was free to leave. It was a perfect opportunity. If this is true, if all this weekend, after 50 hours, all of these things were true, what better opportunity than there for her to leave? She had the opportunity to order what she wanted. She was not being held by myself at all. Now, I know the video played with a little bit of choppiness earlier. I ask you to watch it again and see if you can get it to play smoothly and see that, no, this is a agreed upon situation. We're in there together. We're getting breakfast. We're moving on. I also see that she is cooperative with me. She's using her purse. She has the contents of that purse. And there's no issue that whole time, almost 2 minutes, maybe even more, of going through that drive-through. Logically, I would not be able to get out of that vehicle. I had a seatbelt on, and my door would immediately hit the building. And again, a great opportunity for her to leave. As you look at the Sitco video, there are 3 videos on there. 2 of them show me inside the store. One is from a different angle where you can see that the vehicle is not parked at the first pump. I ask you to look at that. Ms. Mathewson states that I pulled as close to the store as possible and right next to the first pump. That's not true. I didn't have any concern about where I had to pull close in proximity to the store. You can see that from her vehicle where her gas tank is and where you have to pull into the gas station. It's just logic sense. You can also see that I was there inside the store for a number of minutes, And then again, another opportunity for her to just walk away, run away. I remind you guys that this is 6:50 in the morning on a Monday morning. There's
Well, he's
people all
talking
over the
about
place.
logic, and to
Rush
me,
hour.
that's
Objection, Judge
logical.
Jackson, on evidence.
I will instruct the jury again that anything that Mr. Summers or the attorneys for the state say is not evidence, to rely on your own recollection as to what the evidence was in this case and testimony that came from the witness stand. I will instruct you, Mr. Summers, to avoid arguing things at this time that are not in evidence.
Gentlemen, just remind you that they showed the time on the receipt of the McDonald's slip, and that it was a Monday, and it was just before 7 a.m. Also, then ask you to consider the testimonies of the people given. The first is Randall Crosby. Again, he does not recall where I came from. He does not recall what clothes I was wearing, what clothes she was wearing. His statement is pretty inaccurate. He doesn't recall what vehicle it was that was 15 feet from him, even though the name and the insignia is right on the back of it. Only he was focused on was getting that license plate. He was paying attention to that, not what was happening with us. I don't understand how he could be able to look at the vehicle and get the license plate at the same time pay attention to what we're doing. He was also on the opposite side of the vehicle in orientation. He's standing by a red box machine. As you look through the videos, as you look at the overall of that store, you'll see that his position.
Oh, wow.
is
Red
not
box
a
is
very
still a
good
thing.
view
Who knew?
of our position, of Mrs. Mathewson running away, of my position coming out after her. He did not chase us. He did not follow us. He was also the only person standing outside at that time. You'll see a few other people walk into the store a little bit later. All of these people were also available to Miss Mathewson to go and talk to. If I'm in the store, she could have went and talked to him or tried to seek help from him. He also, in his 911 call, you can listen to that, it says that he didn't even know the street location of where he was working. He didn't know that the place of his employment in his testimony, or what time he started the shift, what time he ended. He was also not close enough to hear the things that were being yelled at each other. Mrs. Mathewson said that she yelled. We were screaming at each other as we were going back to the car. But he couldn't hear that.
It was also
then
5
point
years
to
ago,
Kimberly,
so
who gave you a very accurate evaluation of what she saw. Her statement was true. She was pulled in directly across from the passenger side of that vehicle. She saw the emotion on Mrs. Mathewson's face. She saw that we were in some kind of an argument, some kind of a torment. And she also saw Mrs. Mathewson's hand. She saw her hand leaning on the door sill and leaning up against her face. That wouldn't indicate that her hands were tied at all. I also point you to Ms. Shea's knowledge of the exact type of vehicle it was from the moment
evidently
she saw it.
nonstop, Mom.
The position, how far she was exactly from the vehicle.
And I am very curious how this is going to play to a jury
Then
of
we
all
go to
men.
David Chesla, Dr. Chesla. Dr. Chesla did not operate on me as he stated. He also doesn't remember even seeing me. He could not tell exactly what time and what type of medications were given to me. He's only assuming from some records that he may or may not have been involved with.
Let me just stop you right there, Mr. Summers. Everybody knows, or maybe everybody doesn't know, but things like that are documented in your health records while you're in the hospital in any capacity, be it the ER or having surgery done, because not only for just part of the record, but also because it is widely known in the medical billing profession that if it isn't documented, it didn't happen, which means that the hospital then cannot bill for it. So they would not put that you were on certain types of medications if you were not, sir. And so therefore, just because the doctor doesn't remember some patient that he worked on over 5 years ago, that his memory and recollection of events should be discounted because he doesn't remember it, sir. That is preposterous. Sorry.
He doesn't know what the volume of the doses were or what types of medications could have had. He didn't testify to what kind of impact those combinations of medicines could have had. He did
Well,
not
why
speak with
didn't you
law
get a
enforcement,
pharmacist up there?
and
Because that's who
I
the
think
best
his
person
responses
is.
were quite vague.
But whatever.
Then to the other medical professionals that testified.
They're wrong
Teresa
too.
Wagner, Rita Hall, and Francesca O'Neill. They were all involved in some kind of DNA analysis or some kind of evaluation of Mrs. Mathewson's injuries and the sexual battery kit. And again, that sexual battery kit, the test came back, no evidence of rape pointing to me, no DNA match to me. And this happened immediately after the alleged sexual encounters. This didn't happen after Miss Mathewson showered. Her allegation is that this happened on Sunday, and this test happened, and the rape test was given to her on Monday. It also, they also tested the clothing from Mrs. Mathewson, and none of that tested positive for myself being in contact sexually with Miss Mathewson. The sheet from the bed tested positive for my DNA, which the analyst said could have been there that day or sometime prior.
I miss those days, Amelia.
You do know from Miss Mathewson's testimony, we were in contact prior to the 13th, the 11th of March. I also ask you to consider the testimonies given by law enforcement. They were not a witness to anything prior to a simple, peaceful arrest. I did not resist. I did not see, not have any testimony of me causing any problems or acting in any kind of irrational way with them when I was arrested. They did not attempt to investigate, despite all of this available DNA, fingerprint analysis, things that could have corroborated the story, maybe made it a lot more sense for you. But they did not attempt to test the pillows to say, yes, this is evidence of her accusation. They did not attempt to test the Christmas lights to see if there's any trace, as the fingerprint expert testified to see if there's anything on the glass bulbs or any kind of skin, any kind of anything with these Christmas lights. They did not attempt to test all of those items in the vehicle. I asked Mr. Becker, could this have been tested? Could this have been tested? And it was their position that, yes, it could have been tested. And if you think about it, think about all the things. When you look through those pictures, look at all the things that were in those vehicles and line them up with Mrs. Mathewson's testimony and see, would those things have some value? I believe you would find that to be true. I also believe that the contents in the trash can, the rope, they collected it, but it was not tested to see if there were any kind of skin or DNA evidence on that rope.
Did you have it tested while you were busy representing yourself over the last 5 years?
The NyQuil bottle.
I mean, it's not really your burden of proof. I'm just
broken wine
curious.
glass. Look at all these things. They did not check to see if any of those produced any kind of evidence that would corroborate the allegations against me.
I'm
So
sorry.
is
Wait a
that
minute. Let me
reasonable?
pause
Is
you.
that fair?
You are not denying that you were in that home. You are not denying that you touched any of those things. So why would anybody test those for DNA? You've already admitted to being there. What's in question is whether you were there because you intended on harming your ex-wife or you were there to discuss your impending divorce.
They also did not check anything about this statement that they collected from me in a hospital
What?
that was taken after.
I can't.
You know that high dosage of medication was given to me. They did not check to see if there were boat charters on any kind of schedule or any kind of thing that could have even corroborated my story there. They did not check to see if I had offshore accounts. They did not check to see if any of these directions that I'm giving. If you listen to that interview, I'm talking about this road and that road. I don't know. Maybe you guys are familiar with the area. Maybe you know.
Objection, Judge. Go
I
on.
will instruct Mr. Trevor not to place the jury in your shoes or the shoes of any party. Don't make arguments like that where you to the jury.
Okay.
You can argue the facts, but avoid what you just did.
Gentlemen, I would just assert that the law enforcement did not check to see if these directions even fit to a map. And they also didn't seem to think that the statement about immigrants was a little bit out of whack. I encourage you to listen to that video or that audio of this interview and see if someone really does sound like they make sense, or if they sound like something different, in fear, in panic, concerned. Look at the condition that I'm in, look at the medication given, and please draw a conclusion from that. I also submit to you that law enforcement failed to recognize any red flags or false statements regarding if I owned a house and if I was able to just sign it over to somebody. If I owned a car and just able to sign it over to somebody. Or even if the passwords to the bank accounts were valid or not. These all would have been important for you to make a decision about whether or not I was giving correct information. The police also purposely did not interview me when I was awake, sober, clear-headed, recovered. They only interviewed me one time at a hospital where I was vulnerable. That's it. There's no other time. They didn't come and ask me later if I could please explain things better to them. They didn't come with a written statement, ask me to sign it. They didn't try to attempt to get any other information from me. They thought, case closed, he said what he said, and that's it. I also submit to you that law enforcement made no attempt to follow up on the marks on either side of Mrs. Mathewson's neck. Again, they took some basic statements and said, it's been a long weekend. We're just going to conclude here.
Is that what they did? Okay.
Also, could have taken more items into evidence to fill the holes in the story and to corroborate this story. And I believe that would have been much more helpful for you to make a decision in this matter. Then we turn to the children. They only said a few things. I didn't ask them much. I didn't believe they even said too much of value, but the little bit that they did say, it contradicted their mother being dragged down a hall in the house. It contradicted what their mother said about being restrained in the corner of the living room. It also shows that mother had no interest in speaking to them when the oldest, Arden, came into the home, while the youngest two were into there. There was no information given to them. There was no concern to them about while Mrs. Matthews and I are arguing and fighting in the home.
Huh.
And then we turn to the statements of Mrs. Matthews. These statements were outrageous. The statements were exaggerated. The statements were, most of them, impossible. The responses to simple questions were abrupt and over the top. The calm answers, if you recall, they revealed some truths, such as wrestling in the living room. That's a true statement. Such as sleeping in the car. That's true. Such as not caring about sex. That's true too. Such as just calling it sex. That's true. About being woken up by water droplets rather than some other crazy way. If you guys remember the timeline that was presented, they say that I came to her house at 12:30 in the morning. And she finally woke up around 3. Text message showed between me and my children, and I'm trying to wake her up. Showed that I tried to turn on the television loud. I tried to put lights on and off. Tried to slam some doors. I think you guys can understand that. I also ask you to pay attention to the statements that Ms. Matheson made.
But why
She
were
broke
you
the
there to
line
wake her up? Why couldn't you
after
have a
these
conversation at a reasonable hour?
She said
Look, you
nothing
come in.
to our children
I'm gonna pause
to
right
help her.
here. Hold on just a second.
in this alleged situation. She was already in the bedroom.
Please hold for just a moment. Listen, you come into my house unannounced and uninvited at 3:00 in the morning, and you want to have a discussion. You're not going to, it's not going to be a pleasant discussion. I'm telling you right now. Why would you come at 3:00 in the morning? Why wouldn't you come at a reasonable hour? You woke the whole house. Oh, I can't. Let me just mute myself because I'm not going to be able to behave at all. And now my mouse is stuck. Hold on. Come on. I don't understand this at all. This is the most
And she made no
illogical
statement
argument
of
ever.
being drugged back into there. She claims an entire bundle of rope fit in my jeans pocket.
I will say,
Rope, again,
I'm going to have to
not
pause them
to
again.
see if used in any.
I will say this. It is true that if you hold up two pairs of pants that are similar, let's say jeans, okay, and you measure the pockets of a man's pocket and a woman's pocket, the men have bigger pockets. I propose to you that the reason for this is because it's to carry around all that audacity, right? But in this case, it could also be used to carry around all that rope. All right, here we go.
Any allegations. She claims that there was a sock in her mouth, but does not recall those details. And as you go through the evidence, you'll see that no sock was recovered. You'll see that no sock was tested to corroborate this claim. She claims that duct tape was on the mouth, but again, nothing corroborates this. You have a picture of duct tape. You have a very simple thing that law enforcement could have tested and said, yeah, what she said is true. That's not here. You also have a statement about predominantly calling it sex, and then has a cigarette after each time. She offers no details like in the other accusations. We just had sex and we move on. She also says that she was screaming when she came back to the vehicle at Walgreens. Again, no witness made this kind of observation. She says that she opened her car door with her back to it and did not tumble out on the ground. She says that she refuses to recall the majority of the time we were together over the weekend. If you recall, we were together roughly 30 hours parked in the country, in the woods. But she can't remember most of the conversations that we had. She also says that we are driving around on Monday morning between the hours of 6 a.m. and 10 a.m. on some very busy roads. But she made no effort to single another car or really elaborate on any of that time for you. She also states that we argued throughout the weekend, and that should truly help you understanding the range of emotions that were happening, the things that were happening in a divorce situation.
Objection, Judge. Facts, not an evidence.
Again, I'll instruct the jury to rely on their own recollection of the facts were. I'll caution Mr. Summers to please avoid arguing or referring to any facts that were not testified to in this case.
Yes, then we'll go to my interview. If you evaluate me on this statement made in the hospital, I hope you'd find that it doesn't make much sense. I hope you find that there are a glaring number of issues, sometimes in, sometimes out. Things about, again, bolts and incongruent driving directions, about immigrants, about a variety of things that really show a concern for the situation I'm in. So please evaluate that based on the conditions that you know surround that interview. Aside from this, gentlemen, I just remind you that from the beginning, I've assumed my presumption of innocence, and I maintain this until now. I assert that the state has not proven what was in my heart, especially regarding 2 counts of attempt.
Objection, Judge, inappropriate requirement of the state to prove what's in its heart.
I'll instruct the jury that what Mr. Summers say is certainly not the law. In this case, the law will come from me, and the elements of the crimes will be contained in that law. Mr. Summers, restrict your argument to the law and the evidence in this case, please.
Yes, sir. I'll rephrase that, gentlemen. The state has not proved my intentions. They have not proved that I intended in counts 1 and 2 to kill Mrs. Battery. In my statement in the hospital interview, I clearly never said I intended to hurt her. If you're relying on that, that's fine. I never said I intended to kill her with a pillow, and I never said anything about the rope. Never mentioned the incident one bit. I'm also going to assert that they did not show any intent to steal a car. They did not show that that was the underlying reason that Mrs. Mathewson went with me. They did not show me that I intended to kidnap her. There's a lot of holes in their story, and I ask you to please consider that when evaluating whether or not you find the facts true. They also did not show my intent to take advantage of Miss Mathewson in any sexual way. You've heard the way I've described it in my interview. You've heard the way she's described it, and I hope you can appreciate that. I also believe that you would find that they did not prove that I intended to steal a car, which is one of the later charges on this long list that they've put together. I believe you would find that it is a civil matter, and that when 2 people are married, they commonly use each other's vehicles, even if they are separate.
Objection, Judge, improper argument.
Again, I'll instruct Mr. Summers to limit your argument to the facts and the law that are applicable to this case.
Gentlemen, I assert that utilizing cars while married is a civil matter. I also don't argue other issues. I ask you to just be favorable in understanding my position here. I ask you to please be cautious in understanding what burden of proof the state has to provide and how high that threshold is, that you cannot have doubts about these allegations. They are very serious.
Objection, Judge, misstatement of the law.
I will instruct the jury that, again, what Mr. Summers says is not the law. You will hear the definition of reasonable doubt when I instruct you on that law.
And so, gentlemen, reasonable doubt, I believe, is everywhere. And I ask you to please remember that and to please focus on that element that has to be proven by the time that you make these decisions about my life, about the situation that you've been presented, about deciding whether or not to find me innocent or guilty. I ask you to please consider all of these factors and see that what I am trying to show you is that this was a very abnormal series of events, and it requires a lot more information for you to draw a conclusion that would say that I absolutely am guilty of these crimes. And so for all of these reasons, gentlemen, I thank you for your time. I thank you for giving me the opportunity to explain this to you and to share with you a better understanding of putting it together. I thank you for allowing me to paint a little bit better of a picture, and I do appreciate your time, and I value your opinion on this. And I do ask you to please find me innocent of the charges against me and to consider what else may be available to you as you are instructed by the judge. Thank you. Thank you, gentlemen.
Ms. Johnson, rebuttal from the state.
Thank you so much, Nonstop Mom. I appreciate that. Thank you. Okay, I'm willing to stay for her rebuttal. Might as well at this point. I think she said it's only going to be like 30 minutes. So,
May it please the court, Mr. Summers, co-counsel, members of the jury.
Okay, Art and Landon, I need to give you guys some information, and I want you to make sure you understand this. I spent a lot of time with Mom the last few hours, and the things that she's told you about me being good at manipulation, control, and lying is true. And tying her up.
That is Trevor Summers in a nutshell. Manipulative, lying, controlling. And Elisa Mathewson finally had the opportunity to stand up to him on that witness stand this week. She finally got the opportunity to stand up for herself and tell you exactly what happened on March 11th, March 12th, and March 13th. The defendant chose to represent himself, and that you have a special instruction in which to consider that. You are not to base your decision because you feel sorry for him, because you dislike him, or because you like him. You are to base your decision upon the law and the facts and evidence that have been introduced during this trial.
yes, ma'am.
The same goes for any witness that took the witness stand and the attorneys in this case. You must not make any decision in this case because you like or dislike anyone. It must be based solely upon the evidence and the law and the facts in this case. I'm going to touch upon some arguments made by the defendant a few moments ago. He said that there were no dents, no glass broken, no blood at the home. Did Miss Mathewson ever describe the incident of her being pulled from the bed by her feet and taken into the family room? Did she ever describe it in a manner that you would expect to find broken glass, blood, dents in the walls? No. She described it that he pulled her from the bed from her feet. She was throwing items at him, and then he guided her out into the family room, and she kept trying to get up and try to run out that door. That's what she told you. So I would submit to you that the photographs that were taken on March 12th of 2017 of her home clearly depict what had occurred. They corroborate what she told you had occurred in that family room. We see the pillows nicely aligned on the sofa that she was laying on earlier that night watching the Storks movie with Brennan Grady. The pillows are put on the couch in a neatly fashion. Look at the photograph of the way the pillows are on the couch that she tells you that she kept trying to run from the defendant on. They're all on the ground. He says, look at the fact that the cup and the Kleenex aren't where they were. She said she threw them. What do we know about what happened in that room? We know Brennan Grady were in that room after they were told to go back in the room, after the defendant told them to go back in that room and not come out. We know they were in there for some time, worried about their mom, yelling to their mom, "Are you okay, Mom?" And she yells back, "Everything's fine." Could they have picked up the cup and put it on the countertop, picked up the Kleenex box? We know that Miss Mathewson and the defendant were in that room for hours on the 11th. Is it unreasonable to think at some point when he walked in the room to tie her up multiple times, he picked it up, picked the Kleenex box up? No. He said that she was not tied when he went to Walgreens. Why would he take his estranged wife to go see the children for one last time tied up? The problem with him making that argument is that in his recorded post-Miranda interview, he says that he tied her up. So he's arguing moments ago that he didn't tie her up to go to Walgreens, yet in his post-Miranda admission, he told the law enforcement officers he tied her up. He said, I said, should I at least tie your hand so you don't do anything dumb in the car? He tied her up. Talks about the blisters.
Mark.
The blisters that, why would she go walking in this area, or this area was high brush, high dense area, and that's how she got those blisters. And then he was like, well, why didn't you wear flip-flops if you already had the blisters from being tied up? And she explained it. He said they were out in the woods. She described this as a high, densely brush area. And she was not going to wear flip-flops to walk through this, on this journey that he was going to make her go on.
Correct.
To go find water.
Flip-flops are
unreasonable?
not good shoes to wear under those conditions. I feel
He says in the
that's
video
correct.
that he made that he was being nice and asking her what else he should include in that video. You don't see her in that video. She's not a happy woman who just had sex with the love of her life, wrapping her arms around his shoulders on that video. She's hogtied, laying down. That's why you don't see her in that video. He talks about the Walgreens video. He wants you to go back and watch that video. I'd recommend that you go back and watch it, because what you're going to see is you see him walking into the store. He goes out of camera for a minute. He comes back in the angle of the camera looking out into the parking lot. And soon thereafter, he realizes that Miss Mathewson had managed to escape from the car while tied up. And he walks out of the store, and if you keep watching the video, he then proceeds to start running after her.
I
And
wear
Mr.
flip-flops
Crosby
under many
testified
conditions,
that he
but
saw the
those would not
defendant
be the ones I
come
would wear
from
them
the
under.
store running
I'm
to
wearing flip-flops
Mathewson.
right now. It's hot in Florida.
Grabs her. That's how Mr. Crosby describes the interaction. Grabs her and takes her back to the car after she was yelling, "Please help, call the police." If that's not kidnapping, what is? Why would he park in front of the store if he had tied her up and she was going with him unwillingly? You heard Miss Mathewson explain over and over again. She was with him for 16 years. She placated for him. She did what she had to do, so there was not conflict. She did what she had to do on March 11th, 12th, and 13th to stay alive. She was staying on his good side. She was going to do what she needed to do to make sure she stayed alive. That's exactly what she was doing this entire time. And it was finally on the witness stand this week that she was not going to placate him anymore. She was not going to go along with what he said. And she stood up for herself. The McDonald's video is a classic example of what their marriage was for 16 years, of her going along with what he said. He had threatened her before they went through the drive-thru, if you do anything, I'm going to hurt you. So what did she do? She did what she had done the last 16 years and just went along. She knew she had to do that to stay alive.
Yeah, I think everybody thought it was funny, Coolest. I don't think anybody was
She could have
like,
gotten out of the car. I wouldn't have been able to get out of the car. My door would have hit the building. He was in the car. He could have run her over with the car. He had already tried to suffocate her one time. What would stop him from stepping on that pedal and running right into her if she tried to flee? She tried to flee one time. Remember, she tried to flee on March 11th at the Walgreens. She tried, and she was unsuccessful. So she knew from that point on, she had to just go along with what he said until there was another opportunity, or until she was going to be able to convince him to let her go. Watch the Sitco video again. What did she tell you about what happened when they were at the Sitco? She was required to go back to the third row because he knew that the last time he left her in the vehicle, she had tried to run away. So she had to go into the third row and watch the video. Watch his demeanor and his actions in that video. He couldn't grab that dip fast enough from the employer or the employee there at the Sitco. He didn't wait for his change. He goes to proceed to walk out, and then he remembers he wants to get a newspaper. Because why? He probably wants to find out if people are writing about what had happened, the kidnapping of Miss Mathewson, because he had been listening and looking for it on the radio. So he gets the newspaper again. He doesn't even want to hand the newspaper over for the Sitco employee to scan it. The employee almost has to grab it from him to be able to scan it. He throws his money down again and he leaves. And the entire time that he is standing at that,
me too, Allie.
countertop,
It's
he's
going to
looking
depend about
out
the special
window
circumstances
for Miss Mathewson.
on the questionnaire.
Going back for a moment to Mr. Crosby, he says that he didn't know the make and model of the vehicle. He was more concerned about the license plate. Well, what's more important to give to law enforcement? Is it more important to get the make and the model of the vehicle or the license plate? And he is the most independent, non-biased witness in this case. And recall his testimony. He saw her with her hands tied behind, saw her hands with behind her back, running, yelling for help, call the police. And then the defendant, who he can identify, grabbed the victim and put her in the car. He talks about Kimberly Shea, and that she described during cross-examination that she thought possibly maybe her hand was resting up on the door, and that she looked distressed.
Uh-oh. What happened?
And Miss Shea, 5.5 years later, the first time she's saying about the hand on the window was through the Zoom testimony, 5.5 years later. She told you she gave a very detailed written statement that included descriptions of both the male and the female, what she observed.
Hang on, you guys. Sorry about this. There we go.
Car. But that one statement of hers was not in that written statement. But he wants you to hold on to that so tight. But what we already know from his statement and Miss Matthewson's statement and Mr. Crosby's statement is her hands were tied. Because in the interview with Sergeant Remia, he admits that he tied her hands up so she wouldn't do anything dumb.
That is true.
Why would he have to tie her hands up if she had agreed to go with him?
Correct.
Let's talk about his interview for a minute because he keeps harping on the fact of the medication that he was provided, that Hillsborough County Sheriff's Office didn't follow proper procedure in interviewing an individual in the hospital, that his statement was not knowing and voluntarily made. The state would submit to you that 37-minute recording.
Hey, Sugar Babe. Good to see you, babe.
He was provided fentanyl at 12:18. What did Dr. Chesla tell us about fentanyl? It is fast on and fast off. It quickly relieves people of pain and it quickly wears off. We know that there were other drugs prescribed because they generally give nurses options for different pain management. But he told you that looking at the list, none of them had been given other than the fentanyl. None of the other drugs had been given to him. And listen to his recording again. He is clear. He makes sense. He does the majority of the talking. He says, this is just the cliff notes. I can provide more details if you want them. Those are his statements. He's not saying, I can't talk right now. I'm in so much pain. I don't understand the questions you are asking me. Can you come back? None of those things come out of his mouth. He could not been clear on the facts and circumstances surrounding what occurred those last 2.5 days. The DNA. There was no DNA linked to the sex battery kit of Miss Matthewson, of the defendant's DNA. Well, we know from the defendant's own statement that they had sex. The issue for you to resolve was it consensual or not? So the fact that there's no DNA there, he didn't argue to you that they didn't have sex.
I know,
What does that
Sugar
matter?
Babe.
The issue with regards to the sex is whether or not it was consensual. And the state would submit to you someone who sneaks in Miss Matthewson's home in the middle of the night, ties her up, the sex was not consensual. It is not reasonable to believe that someone would consensually have sex with that man after he tied her up with scarves, rope, Christmas tree lights. And that's not all just coming from Miss Matthewson. It's his own statement. He tied her up with the Christmas tree lights. So what would the DNA results on the Christmas tree lights give you? He already tells you that he had tied her up with the Christmas tree lights. What else did we learn from the DNA? from Miss Montgomery O'Neill that if people shower, that's going to affect the DNA. If people go to the bathroom, that's going to affect the DNA. And if someone has a vasectomy, that could affect the threshold. But again, the state doesn't have to put the semen inside Miss Mathewson. He admitted in his own statement that they had sex. The issue is consent. He talks
There
about
was
that law
also a
enforcement
protective
did not
order in
follow
place.
up
Bring that up, ma'am.
on the writings, that whether a house can be transferred via writing, that a car or bank accounts were the correct bank account numbers. The thing with that, ladies and gentlemen, the state would submit to you that he never intended for Miss Mathewson to have any of that stuff. If you look at the note to the children, that explains 100% what his intentions were. His intentions were to kill Miss Mathewson and himself. You decide what kind of letter that was. Miss Mathewson was never going to kill herself. All she wanted to do was get out of the situation alive and to be with her children. He never intended for her to ever get out of that car. So he's going to pretend like, I'm going to let you go as long as you don't call the police. And she's like, I promise you I will not call the police if you leave me these things. But he was never going to let any of that happen. So he didn't care if it was a valid quitclaim deed or a valid surrender of his parental rights, because he knew all along what he was going to do. He knew all along that he was going to kill her. And he was going to kill himself because he was going to be watching his children from heaven. That was his plan all along. He wrote those letters when they had arrived on the Anna Maria Island. They had pulled off. This is coming from Miss Mathewson and his own statement. That's when he wrote the letters. That's when he wrote the confession letter. That's when he wrote the letter of the surrender of the parental rights. That's when he wrote all of these letters, including the letter to the children. But Miss Mathewson never knew that letter to the children was written. She never saw that letter. He was never going to let her know he wrote that letter, because she would then know what the plan was. So he's driving around looking for this flag. That's what he told her. He was driving around trying to get up the courage to do what he knew he was going to do all along. He was trying to find the right place, but he didn't find the right place at Anna Maria Island. So then he moves along to Little Harbor. And that's when he had enough courage, he was going to handle it. He was going to kill her then. That's when he got in the third row and he took the rope around her neck and began to strangle her. And then he jumped in the car and fled because he saw an undercover vehicle. So these writings and the fact that law enforcement didn't follow up on them mean nothing, because to him, those writings meant nothing. He was never going to let her out of that car alive. He brought up Bryn and that her testimony contradicted Miss Mathewson's testimony. She was 7 years old when this happened. 7. What did she tell you, though? She told you that she saw scars on her dad. She told you that she was in fear for her mom. She was afraid for her. Is that contradictory of what Miss Mathewson told you? The defendant brought up the February 18 incident, and the judge read you a special instruction as to how you are to consider that evidence. And the state would submit to you that you must follow that instruction. And one of the ways that you can evaluate and consider that is to corroborate the victim. He talks about how Miss Mathewson can't remember conversations that they had for the 30 hours they were in that car. What did she tell you? She told you that he can just talk and talk and talk about nonsense ad nauseum. Nonsense. And he tries to act like that there was this big tumultuous arguing happening over these 30 hours. That's not what Miss Mathewson told you. She was playing along this entire time with him. There was no arguing. There was no tumultuous situation happening. There was no wrestling in the car. Look at the photographs in the car. Are there things strewn about that it would show that there was some kind of wrestling that he wanted to try to say that was happening in the car? And that's why she got those marks.
I absolutely agree with that,
'Cause he
Sugar
doesn't
Beet.
want
Yes, he
anybody to
did.
think that it could have been
Absolutely.
from him possibly strangling her.
Absolutely, 100%.
Nonsense. His statement, he says about the immigrants and that these boats, about these different times he was going to get these boats. Miss Mathewson was clear. Based upon things in their marriage over 16 years, there were reasons for her to believe what he was telling her. Miss Mathewson's vehicle was not a community vehicle. She left him. She moved into that home herself. She bought herself that car and she had a job. That was not his car. That was her car. His car was the minivan that he decided to send his 14-year-old daughter in to drive the 12-year-old and 5-year-old and 7-year-old home. That was his vehicle. She didn't even know what kind of vehicle he had just gotten. There were no marital vehicles at this time. He had his vehicle and she had her vehicle. And she didn't give him permission at any time that weekend to take her car. Everyone reacts to a traumatic event differently. There is no one formula or way that someone should react to a traumatic event right after the incident or 5.5 years later. This is not a situation where Miss Mathewson was kidnapped by a stranger. This was someone who she had been with since she was a teenager. For 16 years, she had been with him. So she knew what she needed to do to try to stay alive in that situation. And that's why she acted the way she did, why she acted to try and befriend him, to keep him calm, to try to not have conflict.
This isn't important.
Because she
I'm glad
knew
she's
after
mentioning this.
16 years, that was the only way, the only chance she was going to ever have to possibly get out of this situation alive.
Mm-hmm.
The topic of a Baker Act was brought up during the testimony of the trial, but it's clear from the evidence and Sergeant Steele's testimony is that the defendant was never Baker Acted. He was booked in at the jail on the 14th. There was no 72-hour hold on him. He was in the jail the next day. Another thing to consider when he wants you to think that he is not of the right frame of mind when he is making his confession. But you don't have to just rely upon that confession. We have the written confession from him, and we have the videotaped confessions from him. He wasn't on fentanyl then. He wasn't suffering from his self-inflicted wound then.
Sure wasn't.
You have multiple admissions from the defendant. I want to take you through a few inconsistencies in his statements. He had told originally the victim that he had, Miss Mathewson, that he and law enforcement was the purpose of going in there was to say goodbye. He was going to say goodbye.
Amelia.
He needed to sneak into her home to say goodbye. But then he tells his 14-year-old and 12-year-old that the reason he needs their help to get into the home is to address legal issues, and that he was going to convince Miss Mathewson to come home so they could be a family again. Let's talk about the wrist cutting situation, because Miss Mathewson was clear in her testimony that he cut her wrist because he was mad that she had tried to flee from the Walgreens. And it was done intentionally and purposefully. In his recorded statement, he tells law enforcement that he cut her wrist accidentally when he was cutting the rope. Well, let's look at the evidence in the case. We have the back of Miss Mathewson's shirt. The way she wears that is you put your arms through it, it buttons down the front, and where all the blood is in the back. So what does that tell us? What it tells us is that her hands were tied behind her back. She was cut because he was mad that she had tried to flee at the Walgreens. And she bled all over the back of her shirt when her hands were still tied together. He never cut her when he cut the ropes off, because if he cut her when he cut the ropes off, the blood would be on the front of her. The blood would be on the front of her clothes.
No, he has been in the
Miss Mathewson knew
Hillsborough
she would be
County
hurt if she
Jail
tried to flee
awaiting
again,
trial.
or if she tried to flee again. So she went along with him in order to make sure she didn't get injured. And that's exactly what she told you. The evidence in this case corroborates every witness and every detail Miss Mathewson has told you. He tells you in his recorded statement that he's dead tired, so he had to stop. He had to park and drive in those woods. He was dead tired. If he was dead tired, how can you believe his statement that the two of them slept for hours earlier at her home? They slept for hours together. How did they sleep for hours after they had this consensual sex and then he be dead tired? He was dead tired because he was up for over 24 hours. There was no sleeping after this consensual sex. He was dead tired of having to tie her up multiple times and keep watch on her, trying to get into her phone, find out who she had been talking to. That's what he was dead tired from. If you listen to his recorded statement, he almost makes a slip up and talks about this letter that he discusses that he and Miss Mathewson are going to watch the children from heaven. When he starts talking to the Sergeant Remia about the letters that he wrote, he says, drove all the way into Anna Maria. Right before Anna Maria, there's a boat ramp. We parked, sunlight starting to come up, and she wanted me to write some things. And she said if I did that, she wouldn't tell the police anything. So I wrote out, that she can have the house, car, the money, and whatever I left. Just said and then she wanted me to write, no, she didn't want me to write that. He almost said that he wrote the letter to the kids when he was talking to law enforcement, but he knew he couldn't admit to that because his whole floating over, not discussing the strangulation in that post-Miranda interview would be shot out of the water. He almost confessed to but he caught himself because he knew some of his story wouldn't make any sense anymore. He thought he was going to be able to get away with explaining the suffocation of the pillow as a pure accident, a joke. He was just being an ass. But he doesn't even mention the strangulation. He doesn't mention the strangulation because he knew he wasn't going to be able to cover that up once they had found that letter to the children. So he purposefully leaves that out of his statement. It's not a defense. The fact that your estranged wife joins a dating app, that's not a defense to any of these crimes. The fact that she's dating a man that she's now married to, not a defense to the crimes. The fact that she agreed to go with him at one point and changed her mind, not a defense to the crimes. The fact that she has sex with him and is dating other people, not a defense to these crimes. The fact that he wasn't right in the head, needed to go away, not a defense to these crimes. This isn't an insanity case. None of the reasons he gave Sergeant Remia in his confession are defenses to any of these crimes. The state has the burden to prove this case to you beyond a reasonable doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. What does abiding conviction mean? Abiding meaning firm, conviction meaning belief. If you have a firm belief that the defendant committed these crimes, you must find him guilty of those crimes. He had made the decision that if he couldn't have her, no one would, or no one could. And all of the evidence in this case corroborates each and every single witness that the state has put forth to you.
I just want you all to know every time
I
she
briefly
says the
wanna
word
touch upon
corroborate, I'm having a little
The
moment.
aggravation with regards to a weapon when it comes to counts 1 and 2, because the state has charged him with attempted first-degree murder with a weapon. The weapon in count 1 is the pillow. The weapon in count 2 is the rope. The definition for a weapon is 1, any object readily capable of inflicting bodily harm if used in the ordinary manner contemplated by its design and construction, or 2, any other object that was used, threatened to be used, attempted to be used, or intended to be used to inflict bodily harm. He took that pillow and put it over Miss Matthewson's face, pushed down with all of his weight until she wasn't struggling anymore. He used that pillow in a manner that could be used to inflict bodily harm. Therefore, it was a weapon. The rope. He took it around her neck from behind. The only reason he wasn't successful was because she had her hands tied this way and was able to catch the rope, prevent it from going around the front part of her neck. That rope was used in a way that could have inflicted bodily harm. The state would submit to you, we have proven that the pillow and the rope are considered and are weapons on the March 11th date and on the March 13th date. The facts in this case are almost unbelievable. But with the mountain of evidence that the state has proven to you, has given to you for you to look at and review, tells you exactly what happened and tells you that the facts are not unbelievable.
I am delighted as
That
well.
they are as stated.
Amelia.
They are fact the state would submit to you. The mountain of evidence,
We're all
the
inclusive here
overwhelming
at the
evidence
ward.
in this case points directly to the guilt.
We like to
Trevor
get you through
Summers.
all the things.
And we're confident that at the conclusion of this case, you will find him guilty as to each and every count. Thank you.
Gentlemen of the jury, we're going to take a short break. I'm going to give my court reporter at least a little break before I read the instructions to you. There'll also be an opportunity for you to stretch your legs, use the restroom if necessary. It will be a short break. We'll come in and I will read you the final instructions, and then you will return to the jury room to deliberate. Please do not discuss the case amongst yourselves with anyone else. Please do not do any research related to the case. All rise for the jury.
All right. Hold on a sec. Let me stop sharing. And we'll talk real quick. Stop sharing. All right. Close this. All right. So, hold on. I got to let my computer catch up to all the things I just clicked. All right, there we go. So I am very interested in the fact that this is an all male jury, because like I said last night, honestly, like with any other jury, you know, obviously it can go either way. But I'm really curious how compelling they found his closing statement. Now, granted, a closing statement obviously is not it's not evidence. They're supposed to go only on the evidence that is submitted. However, what a closing argument will do is point you to the evidence, right? So when he talks about the way that the house looked, right? The evidence of that would be the photographs. And I'm very curious to I'm curious. What I would hope for is, however they find, you know, obviously we'll find out, right? But what my hope is that some of the jurors, at least one, will be goes for an interview, has an interview, because I would really like to hear their thought process on this. And you know, Sugar Bee, you'd think that, but no. Every year, all year, people flock to the Floridas for their vacays. I personally think that the most important part, in my opinion, of the rebuttal closing argument made by the state was to address the way that Mrs. Matheson behaved during this time, because and that it's related to the fact that this is not a stranger to her, that they were married for a number of years, that they were teenagers when they got together. And that's very, very important, because the way that a human being would behave, first of all, trauma is different for every human being. Are there some generalities? Yes, there are. But by and large, humans handle and react to trauma and fear in different ways at different points, right? And it's especially true when you're dealing with a situation where it is a stranger versus somebody that you know. And then an additional layer to the somebody that you know is that it is an intimate partner, i.e., a spouse, especially one that you've been with for a number of years. And further bolstering that argument is the fact that there was already a protection order in place. So that lends credence to the fact that there had been some history, obviously, of violence in because she was able to get a protective order. So for her to use in her closing argument that the reason why the victim behaved in the manner that she did is because she was familiar with his, for lack of a better word, honestly, what she was saying is she was familiar with his brand of bullshit and she knew how to deal with him. And she knew exactly what she needed to do in order to have the best chance at surviving all of this, which is why she acted in the manner that she did. And once she made the initial attempt at escape in the Walgreens parking lot and was returned to the vehicle, she knew that she must continue to behave in a manner to gain his trust. And that would increase her chances of survival. It is when you know your captor on a personal level and an intimate level that way, it does make it a little bit easier. And I don't like to use the word easier because it's really not the appropriate word, but you are, let me change that, perhaps better able to predict what would give you your best chances of survival versus it being somebody that you've never seen or known a day in your life, right? That would make sense. And I think it was really important for them to close with that because his whole entire argument in closing was essentially, look, we were going through a divorce. This was like a last ditch effort. Yeah, I probably did some things that insight. Thank you, Sugar Beet. I probably did some things that I shouldn't have done. I was out of my right mind a little bit, but none of this is what she's saying that it is, right? And I think that as he continued to draw parallels to her behavior. Well, why didn't she do this, that, or the third? Or how come this, that, and there did the house basically didn't look like a struggle had taken place. It looked like, and why didn't she try to involve our children? And that's an interesting point, Mark. But what I will submit to you is, he saw something was wrong, right? Something was not right about that situation. And perhaps the reason he didn't call out was because he didn't want to draw attention to the fact that it had been witnessed and thus putting the person in danger, more imminent danger. Do you know what I'm saying? He doesn't know the relationship between those two people. All he saw was a man and a woman struggling, right? And perhaps his thinking was, let me just get down this license plate number, call it into the sheriff's department, and be quiet about it on the low so that this person doesn't know that he has been seen and that it doesn't cause him to escalate and unalive his victim quicker. Does that make sense? I he was blaming the victim. Well, it's not that he was even blaming the victim, Sugar Beet. What he was doing is saying she wasn't a victim at all. And to your point earlier, I wanted to address this too. Where is it? I think it's up a little bit. Because right here. The only criticism I have is the state should have protected her more on the stand. And I thought about this last night after the live ended, after we watched it. And I was thinking about that. And why didn't the state intervene more? And I think that the reason that they didn't is because I think that they wanted the jury to see him. You know what I mean? That he chose at what would, if your intention is to re-victimize your victim, right? The most opportune moment to do that would be firing your attorney, because he allowed his attorney to be the lead counsel all through jury selection and for the majority of the beginning of the trial. He did not fire his attorney, which you can't, I mean, let the attorney go. I guess fire is not really the right word because he wasn't paying for the attorney, but you know what I'm saying. Until she had testified for hours, because she started out at the end of Tuesday and was pretty well through her testimony Wednesday. And at the morning break, that's when all of this happened. And of course, this is the conundrum, right? Because it happened on a break, right? So she was in the middle of testifying. She was still giving her direct test. She was still on direct. And so because of that, the state would not be allowed to speak to her. They would not be allowed to let her know that he was going to be able to cross-examine her, because you can't talk to witnesses and the witnesses can't talk to anyone. And yes, it was brutal, but I think that the state took a measured and calculated risk with that, because I think that they really wanted the jury to see him and really what he was actually doing. He wasn't trying to defend himself. This is the state. He was trying to re-victimize her. And I think that they needed the jury to see that. And especially the timing of it. So I think they took a calculated risk, and I know it was hard for her, but I will say this. She had talked about this prior to the testimony, and he had been sort of playing the system this entire time. Like at first he had retained attorneys, paid for them, let them go. Then he was pro se. And then at the end, yes, it was very difficult to watch. And then at the end, he had an attorney, but he was still it was all very last minute whether or not he going into this trial, whether he was going to represent himself or use the attorney. And then Monday, when jury selection began, he decided that he was going to use his counsel. But bottom line was, she was, as much as you can be, prepared that there was a potential that might happen. And so I think it showed her courage and her strength to be able to um, s- keep her composure under those circumstances, because this has been dragging on for a long time, and there is, for her, until all of this is behind her, that there can be no moving forward and closure process, you know. So I thought it was remarkable how well she did, and but it was brutal to watch. And I don't know, I was saying last night, I don't know what the answer is, because you know, under the Constitution in the United States, we have the right to face our accuser. And typically that means through our attorney, right? We don't typically get up there and question our accuser, but we do have that right to actually get up there and question our accuser. And so I'm not sure what the answer is to protect a victim in that way while still protecting the defendant's rights under the Constitution, because you are innocent until proven guilty. This burden in a trial in a criminal trial is on the state. It is not on the defendant to prove his innocence. It is on the state to prove the defendant's guilt. And I just do not. Bye, Nonstop Mom. Thanks for being here, babe. I don't know what the answer is. I don't think there is one. I don't think there is a way that you can protect the victim and the defendant's constitutional right. I just don't think there is. I think it's thankfully it doesn't happen often. But anyway, we'll all be on verdict watch, and I'm not going to go live tonight. I will be over on criminality. She is going to be live. I'm not going to be on panel, but I will be in the chat. And if we get a verdict today, I'll just go live like Saturday at some point. Just let me highlight that. Just being honest, alimony has a big part of this. I can understand the complexities of a divorce and everything that goes into it. I don't know that alimony. Let me look up Florida. I think that Florida is a no fault divorce state. Let me look. And she was working, so I don't even know if she was going for alimony. I'm hold on a second. You want to come up? Hold on, Mark. Just for a little while, because I've been streaming for 4.5 hours and I got stuff I got to do around the house. So I'm going to drop the link for you to come up, but I want to look this up really quick and see. I'm pretty sure Florida is a no fault state. Florida is a no fault divorce state, which means that if a couple no longer gets along, they can file for a dissolution of marriage. A spouse may file for divorce without his or her spouse. Yep. Hold on, I want to read this though. Let me see what this says. Huh. I don't care about really adultery. I'm trying to figure out. I don't know that they were even going, I don't know that she was even seeking alimony, but maybe she did. I don't know. I didn't look into their divorce. So maybe she, I mean, okay, she got adultery. She got alimony. Okay. I mean, it's not a, in my opinion, it's not a just, I don't know if you're, I don't know what, I don't know how to, I'm trying to think of how to respond. I know what I think what you're saying by saying what you're saying is that by bringing up the alimony is not that this is a justification for what he did, but it goes to his mindset. I think that's what you're saying. I dropped the link, but are you going to click it? I'm not trying to be rude or anything, but because I gotta get off of here soon. I'm probably good for maybe like 10 minutes, maybe. And then I gotta go. But I tell you what we can do is, I'm just going to go ahead and say Saturday night, and I'll just have an open panel and we will discuss all the things, like not just this case and this trial, but, there's another trial in Ohio that's going on simultaneously. All of that. So, maybe we should let's do that. Mark, if you don't mind, can we just put it off until Saturday night and I can have an open panel when I'm more prepared? Like to stay, not that I'm always prepared for a conversation, but I need to be prepared to stay. So because I've been like, this has been a while. Oh, he's absolutely guilty. I am curious, though, how all of this is going to play out in the minds of the jury. And I'm curious what, obviously, we all are, what their verdict is going to be, right? But more importantly, I am curious about, once they render their verdict, what their thought process was, which is why I would love for one or more, but at least one of the jurors to grant an interview, because an all-male jury is, like rare now. I mean, obviously back in the day it wasn't, but we're not back in the day. We're now in the day. And it's a rarity. And I'm very curious about all of this. So I'm going to end it for now. I will see you guys. Hopefully I'm going to share it to my community tab, the link to Criminalities Live tonight. And oh, you guys are all welcome. Thank you all for being here. And I will have an open panel on Saturday night, and we're going to talk about anything and everything that you guys want to talk about. Except for drama. Let's just talk true crime, okay? There's enough drama in the true crime. We don't need to, you know what I'm saying. All right, you guys. Have a great rest of your Friday. Stay safe out there in the world and on these YouTube streets. And I will see you live on my channel Saturday, and I hopefully will see you in the chat over on Criminalities channel. All right. Bye, you guys. Thank you again for being here. Bye.